meeting, which we're calling to order. Would you please join me for the Pledge of Allegiance? The first item on the agenda is Appeal 3210, the applicant Villanova University, property located at 800 East Lancaster Avenue and zoned PI Planned Institutional and CO Commercial Office. The applicant seeks to construct a welcome center / bookstore building on its campus in the area on the south side of Lancaster Avenue, adjacent to the existing pedestrian bridge. The applicant seeks a special exception, or special exceptions, plural, in the CO district under Section 280-101A, number 1 in parens, and 280-101A, 2 in parens, to change one nonconforming use, a dormitory, to another nonconforming use, a retail bookstore, and to expand the nonconforming use by no more than 50%. No zoning relief is being requested in the PI district. Applicant also requests a variance from 280-123B to place the lettering for the naming of the building above the arch which spans the roadway. The lettering at its highest point will be 20.5 feet above grade. In the alternative, if necessary, applicant seeks a variance from Section 280-42 of the code for the proposed use of the building or such other relief as required in accordance with the exhibits and testimony presented at the zoning hearing. Now, this hearing tonight is continued from the hearing on June 26, 2025. At that hearing, we took all testimony from both the applicant, Villanova, and from the township, who elected to be a party to the application. So the record was closed as of that time, so there will not be any public comment, but we will have each party will have 5 minutes to take as much as 5 minutes to sum up their points that they think they would like to make. Questions will be asked at that time by the board, and we will render our decision. Nick?
Thanks, John. Nick Cornelia, representing the applicant, Villanova University. As the chairperson stated, these were requests for 2 special exceptions to change one nonconforming use to another nonconforming use and to expand that nonconforming use by no more than 50%. The other request for the variance was for the sign and the height of the sign above the arch where the structure would be located. This is a split zoning district, as you're aware, PI district and the CO commercial office district. These uses are permitted in the PI district, where it still would require conditional use approval by the Board of Commissioners to expand that the CICD if this were granted by this zoning hearing board. So really what we're focused on is the part of the building that is located in the commercial office zoning district. The commercial office zoning district is just like it says, it's an office type district. There exists in that district an existing dormitory. And that entire district and an entire piece from the CICD all the way down to Sproul Road is institutional use. It is institutional use by Villanova, mainly offices. And as I mentioned to you that the dormitory, I believe, is a 48-bed dormitory and a 9,797 square foot building. A special exception, as the board knows, is not really an exception to the ordinance. It is something that is permitted under the ordinance provided the applicant complies with the objectives of the ordinance as specifically stated in the ordinance. In this case, there are objective standards, such as for the nonconforming or the expansion of the nonconforming use to 50% and a couple others that we will discuss. And then there's general standards. The general standards is a very heavy burden on the opponent to prove by clear, convincing evidence, beyond doubt, that that is harmful to the health and welfare of the surrounding community. It has to be a high degree of probability. It can't just be speculation. So on the objective standards of the ordinance, as was stated in both briefs, it references to existing lawful buildings, lots, and uses. This is an existing lawful building. It is a dormitory that is a nonconforming use, a legal nonconforming use. The parties have stipulated to the fact that this is a legal nonconforming use. And everything revolves around this existing nonconforming use in the CO zoning district. Now, as I mentioned, Villanova requests to change that nonconforming use. Really, the only objective standard in the change of nonconforming use is that the building is an existing nonconformity. And as I stated, that's been stipulated to by the township itself. What you have to remember when reviewing everything here, too, is that any ambiguity in the ordinance has to be determined in favor of the landowner. That's clear by case law and by municipality's planning code as well. So the township also states that we have two multiple uses that we're intending to put in here. As I mentioned, the office use is a permitted use. It is going to be an admissions office. An admissions office, part and parcel, has a large room for when the people come in, prospective students come in, and they're shown film and things of that nature. Just like any real estate office, you would have people come in and speak and talk and things of that nature. That doesn't disqualify it as an office use. In this instance, the admissions office and the permission for the admissions office in the CO district was stated by the zoning officer in his determination letter that the use was permitted as an office use in the CO district. You have his opinion there. It's marked as exhibit. You have seen it before. It's mentioned in the brief. Oh, okay. Wow. We even get 10 minutes in the appellate courts. And then, as to the expansion issue, again, there is a couple standards there. Again, permitted legal nonconformity. We're not expanding it by more than 50%. The retail use that was existing with a nonconformity was 9,000 square feet. Approximately, we're expanding that to about approximately 14,000 square feet, which is less than 50%. You're no more than one expansion. And then there's a conformity to area, height, and setback. It does not mention conformity to parking, although we've presented testimony that would comply with the parking requirement in the CO district for all the CO buildings, even not considering the merger argument that we made in the brief, because the township was trying to state that there's a setback requirement between the PI district and the CO district. The PI CICD specifically states that there is no setback requirement between the CICD and any other property of the university or the applicant under that CICD. Also, Villanova has always used this as a single parcel. We presented testimony and plans showing that prior calculations by the township has always treated this as one single parcel. I've been representing Villanova for almost 40 years. It's always been treated as one single parcel. Now, for some reason, they're requesting that each parcel be considered separately. As to raising the building, it's clear in case law that any attempt to limit a nonconformity must be stated in the ordinance. There is nothing in the ordinance saying that you cannot raise a building or demolish a building and build a new structure. So that argument by the township, I think, is specious in that it's obviously not provided for in the ordinance as to the restriction. As to detrimental impact, we presented traffic testimony. We presented testimony from Mr. Tavani. There was no testimony at all from the township to rebut his testimony. Also, as to location, if you look at nuisance characteristics, this is in a planned institutional district. It's Villanova Institutional District, and the traffic generated is already existing traffic anyway. The hours of operation are less than the hours of operation for a dormitory, which is 24/7. I think the important thing to remember, just in closing, is that there's a heavy burden on the township to rebut the evidence and of the applicant on this, particularly regarding traffic and the general obligation as to health and welfare of the community. Thank you.
Good evening, Zoning Hearing Board. My name is Will Ettinger. I'm here on behalf of John Rice from the Solicitor's Office. If you understand or if you're aware of the circumstances of John's absence, you'll excuse me if I'm trying to catch up on the record and the law surrounding this case. To echo Mr. Cornelia's arguments, the board has before it two special exception requests that relate to the expansion or conversion of the nonconformity. I'm going to kind of take them in reverse order and deal more with the expansion, the 50% expansion first. So when we talk about a 50% expansion, you start with the floor area of the nonconforming use, and that's roughly 9,500 square feet for Moriarty Hall. That allows for a nonconformity of, I think that it comes out to about 14,600 square feet, and that accommodates the bookshop only. And I think the reference to Mr. Kochansky's zoning opinion letter is a letter in which he described administrative offices as being permitted in the CO's district. Therefore, administrative offices would not necessarily be included within the definition of a nonconformity, right? Because we're taking office space to office space, which would be permitted. I think the conclusion that a welcome center is itself office space or is administrative office space, while it may contain administrative offices, and I'm not disputing that there are administrative offices within the welcome center, I think the bigger question is that truly all that the welcome center is? Is it just administrative offices? And I would submit to the zoning hearing board to think about the welcome center a lot like you would a car showroom. It's somewhere that you come in. There might be offices in the back where the employees work, where the public's not welcome, but it's really a place where you come in and the public is shown, they are sold, they are told about the university, and they are, essentially the university is trying to get them to enroll. When you look at the floor plans that are associated, and I think it's around applicants 7 through 11, there are improvements to the property that include model dorm rooms. There are lobby spaces. There's the auditorium. I'm not saying that an office can never contain these uses, but it's really more of a public-facing building than it is a pure office space building. So I think when we talk about that expansion, it's not just the retail bookstore. It's much more than that that's being proposed here. Mr. Cornelia accurately stated the standards with respect to special exceptions. There are objective standards, and then there's a burden shift. I think the question is really one of law primarily, and that is when we are shifting from one nonconforming use, are we shifting now to one nonconforming use, or are we shifting to multiple? And I would submit to the zoning hearing board, we're switching to multiple, and we're really stacking uses, stacking square footage, and there's much more nonconformity to this proposal than is being suggested by Villanova. With respect to the variance for the sign height, I don't think there was any testimony that this was anything other than aesthetic. The board's, I'm sure, well aware of the standards for a variance and that pure aesthetics does not meet the requirements for a variance. There's no hardship tied to the land with respect to that portion of the application. I'm happy to entertain any questions from the board.
Excuse me, it's really just a simple question. It's 280 point,
One-
280-68.1 F4.
Okay.
Does that apply?
You're gonna have to, I'm sorry, I can't quote a chapter and verse.
That's okay, yeah. And you can take a minute and read through. That should be the whole section there.
And you're just looking at F4, I'm sorry?
You could certainly comment on the whole section if you want, but I think F4 is really what the applicant brought our attention to. I'm sorry to catch you off
No,
guard.
that's all
That was
right.
not my intention.
I think the parenthetical in the middle of F4 is what is operative in that section, because it discusses the separation between roads. So you have the exception that says that a setback doesn't apply if you're contiguous, except where broken apart by roads. And I think that's exactly what we have here. And I want to say it's St. Thomas Way that cuts right down the middle between the districts.
Right, so my understanding is St. Thomas Way is a private road. I'll use the word road. Is that what's contemplated by that parenthetical, a private road as opposed to a publicly open street?
Yeah, I think it's any, I would say any right-of-way, we'll call it. I think you're dealing with an admittedly unique situation in Pennsylvania zoning when you're talking about a university which almost functions as its own city. And but when you talk about, first of all, the road just happens to align with the zoning district, which I think was likely intentional. If not, even when we're talking about private roads, roads can be offered to dedication for the township. You have private roads in private developments. I think it's a too narrow a view of a road of the term road or right-of-way to exclude any private roads from that definition. I'm not going to stand here and if nobody else has any other questions, thank you for your time.
I'll make it, although I think it's a complicated motion.
I think you need one motion for the special exceptions and another one for the variance argument.
Okay.
You don't need the second one.
Okay, Mr. Chair, I'll make a motion. So I would move that the application be granted to permit the construction of the Welcome Center and a special exception be granted under section 280-101A1, and which permits the substitution of one nonconformity for another, and 280-101A2, which permits the expansion of the nonconformity by no more than 50%. In accordance with the plans, exhibits, testimony, and the record that was created in this application.
I'll second the motion.
Yeah, I'll go, sure. So, this is unique for me. I'm an attorney, I practice law, and I've never researched trying to figure out who's right on the law versus who's wrong on the law. I always have a client that I need to find an answer to, and I argue it. This is the first time I've read cases and sort of shrugged my shoulders as to who's right and who's wrong. So I'm going to read through some remarks that I've prepared, and hopefully they're logical and make sense. So special exception under 280-101A requires that the proposed new use be no more detrimental to its neighborhood and surroundings than is the use it is to replace, provided there's no resultant nuisance, which I don't think we have here. Although traffic will be dispersed amongst campus in a different manner, there's no reason to think that the Welcome Center would invite more traffic than current conditions. The question the township asks us to consider is whether the right to extend a nonconformity applies to existing nonconforming uses only and not proposed nonconforming uses. The language of the ordinance seems to suggest that the township is correct in as much as it refers to the current nonconforming use. The cases that I read did not seem to address the specific fact pattern that we have here. And really all the cases that I read are really distinguishable from what's in front of us. In those cases, the applicant was proposing different variations of continuing the existing nonconformity, albeit in a new structure. I found no case where an applicant first sought to change from one nonconformity to another and simultaneously sought to enlarge the footprint. Nevertheless, the law seems to suggest the right to the nonconformity runs with the land and not in the structure itself, and therefore a change from one nonconformity to another should be no issue. Nor does it make sense to me to require the applicant to come before this board to propose an expansion of the existing nonconformity, only to return in the future enlarged footprint in hand and then ask us to change the nonconforming dormitory use to the desired retail use, or for that matter, vice versa. I do not think that approach makes sense, and therefore I do not agree with the assertion that 280-101A would otherwise prohibit the change in use while simultaneously allowing for an expansion. I do want to make a footnote to that. I was given a case this week that has nothing to do with zoning. It had to do with joint tenants with right of survivorship. I definitely don't want to go into a law school dissertation, but it was always my understanding that we could go from one joint tenant to another in a deed and destroy the survivorship rights. The Supreme Court came out with a case very recently that suggests that you actually have to use a third party and it would require two deeds, so you need a straw man. So perhaps jumping through hoops is what the Pennsylvania Supreme Court requires. Nevertheless, I'm not convinced that that's appropriate in this case. I think that case is doesn't make much sense to me. Anyway, so I don't think that the code or the law requires that double approach to replacing a nonconformity and then expanding it. I think it's appropriate to do it all within the same application. The next question then is whether the proposed use by the admissions office is truly an office or whether the quote institutional uses, if they have been referred, are distinct from the office use and therefore represent multiple nonconforming uses in addition to the proposed retail store. At first, the idea of the Welcome Center as part and parcel of the admissions office use struck me as incongruous and therefore required multiple nonconforming uses to be approved. The parties have used the term, quote, institutional uses, and while I think that's a good descriptor, I don't think it's the right term. I do not believe the use of that term negates the overall office use contemplated by the applicant. Certainly an auditorium is not what we would consider to be needed in a traditional office setting. However, I think that is too narrowly construed. Part of the duties of the admission office is to invite prospective students to campus to meet with admission office staff and ultimately to tour campus. A large reception and waiting area and small conference rooms are traditional office amenities. But an admissions office is not a traditional office because of its expanded duties to host prospective students. The testimony of Matthew Harris confirmed that the auditorium is not designed to include, quote, back-of-the-house amenities, but rather to serve the purpose of hosting a large group of prospective students and their families before they tour campus. So while a 300-seat auditorium is not something I would consider necessary in a traditional office setting, it does strike me in this setting as part of the overall office needs of the admissions office. It is a necessary component of their specific use. I also believe that concepts of traditional office have evolved. I'm in Lincoln Financial Center, and that building contains a rather large reception area and waiting area with couches and other amenities. It includes a small cafe, and importantly includes several large presentation or conference rooms designed to handle large groups. I don't know that you can get 300 people in any of those larger conference spaces, but that's not the point. While an auditorium uses some sense of stadium seating to ensure adequate sight lines to the front, I do not think that is much different than a large conference or presentation room. Therefore, in my analysis, the office use is permitted in CO and requires no relief from the board. The only question then is whether the applicant is entitled to change from one non-conforming use to another, i.e. the proposed retail space. Given the evidence of no increase in traffic or any other detrimental consequences, I believe the applicant has met its burden for the grant of a special exception to change from one non-conforming use to another. However, the applicant cannot meet its burden with respect to the ability to expand the nonconformity under 280-101A2C unless the doctrine of merger or an ordinance eliminates the setback requirements. So, setbacks. It seems clear to me that Radnor's zoning code contains no merger ordinance, and therefore the doctrine of merger is not anything this board should consider. Quote, it is well established that mere common ownership of the adjoining lots does not automatically establish a physical merger of those lots for the purpose of determining whether those lots comply with the zoning requirements. That's from Township versus Jones. Quote, the doctrine of merger does not exist as a matter of common law, and therefore the merger of adjoining lots held in common ownership is totally dependent on a merger provision in the relevant zoning ordinance, end quote. That's from In Re Jerahian, Jerrehian. Therefore, quote, a merger of lots provision in the applicable ordinance is the starting point in the analysis of whether merger has taken place. And that's from a case called Loughran, L-O-U-G-H-R-A-N. Although the evidence is unequivocal that Villanova has maintained the property as a unified parcel and manifested its intent to do so from the intersection of Ithan and Lancaster west to Sproul Road in Lancaster, the law does not permit us to rely on merger in the context of this application. Therefore, if there's no merger, then the proposed building must conform to setback requirements contained in our code. Applicant directs us to 280-68.1D2F4, which seems to eliminate the setback requirement. The last clause states, quote, no setback shall be required regardless of zoning district. I asked counsel for the township about that, and while he is right, that parenthetical talks about not separated by roads. The code is silent on what exactly that means, and as a result, I think we cannot read it against the applicant under Pennsylvania law. So therefore, I think those provisions do apply, meaning the CICD is adjacent to other contiguous lands owned by the applicant, which are not separated by roads, railroad property lines, or rights-of-way. St. Thomas Way is a private road and does not completely intersect the two lots. Therefore, we can either consider, strike that. If no setback is required, then the applicant has met its burden under 280-101A2C. So for these reasons, I'll be voting to approve the application to expand the nonconformity because the proposed building is not subject to setback requirements otherwise required by Radnor Code. Since I have the floor, for the sign height, my recollection of testimony, I know that's not the motion before us, but I'll just take advantage of my time. My recollection of the testimony was that the need for the variance was in order to accommodate a fire truck to pass under the proposed bridge, and as a result of that, I think the necessary hardship has been proven, and I'll also be voting in favor of that. So just to summarize, I will be voting in favor of granting a special exception to change from the conforming dormitory use to a non-conforming retail use. I believe the code does not prohibit the expansion of the non-conforming use, and because the code eliminates setback requirements in property adjacent to CICD, the building is not subject to those requirements. I'll therefore also be voting in favor of granting the special exception to expand the area of the nonconformity under 101A2. Lastly, I believe the concept of the Welcome Center to be used by the admissions office falls within the definition of office use within the CO zoning district, and therefore submit the use falls within the district's permitted uses.
So I have a little bit different take. Appreciate the thorough research, Rich. But I guess for me, the language presented that you had counsel read strikes me as a plain reading of the law is that a road is a road, and because it doesn't differentiate either private or public, I think the all-encompassing notion of road should apply regardless of private or public. So that's kind of my position on the setback issue. Relating to the Welcome Center, I appreciate the conference room analogy because I think that is an apt way to kind of describe how one should look at the office or expansion of an office and the utilities of the office. But I guess I differentiate in the sense that a conference room functionally acts as an office for more people, where the Welcome Center's auditorium and things are not acting. You're not signing paperwork in the auditorium. You're not reviewing one-on-one with people. You're not discussing these issues. It is to present information, which I think is different than how a conference room functions in an office place. So for that reason, I don't really see the Welcome Center is just an office. I think it's more of a Welcome Center. Regarding the sign issue, I completely agree. I think the fact that it's being elevated is for the vehicle to come in for safety reasons. I think that's a perfectly fine burden to justify that. So that's kind of where I'm at.
I guess what I was considering in terms of office use is, you're right, this is not a traditional office because we're talking about a school, an institution. But nevertheless, it is an admissions office who handles and serves the university by acting in an office function. So the idea of auditorium or conference room for presenting information, to me, you're still, whether I'm sitting in a conference room or an auditorium, if I'm being presented information that falls within what that particular office does, that's why I feel like it is part of that expanded. But I'm not necessarily trying to convince you.
I was also vacillating over the office question for a while, and that's like with the company I work for, we have nearly 1 million square feet of office space. I'm familiar with the current market and where that's going, and the questions surrounding kind of the definition, I'll say, of office space. But I have seen in my work the office being used as almost as a showcase space. So I know there are model dorms here. In the presentation of information, you can go to office spaces that can show you how your furniture would be in your office space, or how your business may be able to be set up. So I'm leaning towards the fact that this is, albeit not traditional office, it falls within that definition of for commercial office space.
I don't agree that the huge hall is an office, so I can't support that. In addition, I agree that the setback requirements hold, not just because of the road, but my reading and understanding, at least when we passed CICD, the setbacks were limited in the CICD, not the adjacent district. So I don't see it as being a valid argument. As far as the arch and the argument of the fire trucks, there are alternatives to that. There's at least 2 other ways into that property. So I don't know that that's a valid argument. and I'm not going to vote to support this, which kind of moots the question of the sign.
Well, I thank the members of the board for their observations. They're all well taken. I did have some problems with various aspects of the application. It seemed as if we were stretching the rules and stretching the law and perhaps lapsing into a little bit more of a legislative mode than a deliberative mode, and legislation is not our brief. We're to decide these cases based on the Radnor zoning code, and it's not our role to be legislative and move things around to fit the need if it doesn't otherwise satisfy the requirements of the zoning code and the case law that you heard, some of the case law that you heard cited here tonight that has interpreted similar provisions in other townships and municipality zoning codes. Now, having said all that, I've come around to the belief that the special exceptions should be granted. I don't think we're going too far over the overboard by any stretch of the imagination. There is room to flex a little bit without leaving the reservation, but I think that this is the sort of thing that most colleges and universities would have, and it's been a while for me, but I took 3 children to various universities for them to look at it, and my recollection is every single one of them put you into a room which had like a little auditorium. There were a complex of offices and other space that was devoted completely to the notion of admission to this particular school, whatever it may happen to be. And that almost invariably included maybe not a bookstore, but it's a place where you could buy school paraphernalia to help you bond with the school even before you got, in my case, that had to write out a check. But I think that, so I think you can find issues and you can argue against certain portions of this, but I think that on a large measure, it's, I would support that. Now, the one place where I do have a continuing problem, and I have not been able to erase this from my brain, and that is on this doctrine of merger. We don't have a merger statute, and from what I understand, if Radnor Township doesn't have in its code a merger provision, then merger doesn't apply. And I'm willing to listen to some more argument here. This has been very instructive, that this distinction between the PI and the commercial with the road, the St. Andrews Road or whatever it's called, coming down the middle. It almost seems a shame to get to this point and then stop the show because of the lack of a merger statute. I don't think one can be presumed. I think that's just going too far in moving the code around to get to that point. And if anybody here on the board would like to address it further, I'll be certainly willing to listen to it. But right now, on that one particular ground alone, I find myself unable to vote for it based on that. Which then, of course, we won't reach probably won't reach the issue then of the signage.
Well, are you asking the applicant?
This is not a road, it's a driveway. Now, Villanova named it St. Thomas Way, but it's a driveway. It's a driveway to campus, a driveway to West Campus to the CICD. It's not a road, it's not a private road, has no right-of-way.
Well, is there something in the statute that says it has to be a public road?
It says must be a roadway, but this is not a roadway. It doesn't
It's not
say,
defined in the statute, is it?
I'm sorry,
What it is not defined. as a
it's not
road.
defined.
Okay.
Exactly. And for that reason, it has to be determined in favor of the applicant.
Well, Mr. Keneally, can you also address the issue of St. Thomas Way? Does it completely intersect those two lots?
I believe that, but I don't think it goes all the way back, does it, Chris? I'd have to, well, it should be
Well, my
on the
understanding-
plan. It would be on the plan, I think.
Right, and on the plan, it shows a drive going from Ithan all the way across to the CO district, I believe.
Is that the roadway that runs all the way in the back?
That's what, It
Parallels the
runs
tracks.
and then it goes behind the parking for the CICD. Right. There's a driveway that runs parallel to train tracks.
Yes. And then
So,
the-
but that is not St. Thomas Way. That's a driveway, just like St. Thomas Way is really a driveway. It's just going to Villanova's dormitories under the CICD and to the commercial office area that they have.
Does
It's
St.
not a
Thomas Way
roadway.
connect with the road that runs at 90 degrees to it? Does it connect with it? It does not? It's for SEPTA parking?
Yeah. And actually, if I can pull, just look if I can. I just want to pull.
Mr. Chairman, hearing board argument, I'm wondering if we need to restructure the motion that I made and maybe break it down into its elements.
Well, we haven't voted yet, so I think we can do that.
Yes, looking at the ordinance, it says not separated by roads, railroad lines, or right-of-ways. And then it says no setback shall be required regardless of zoning district.
That's my question, is it separated? If St. Thomas doesn't go all the way through, and it stops with a, whatever you want to call that drive from Ithan across to the CO district, is it a complete separation or not? And that's what I left up to the board. That if the board feels as if, because St. Thomas Way doesn't reach all the way to the end of that lot, are the lots separated? And that's for the board to decide. But I think that was an important issue that needs to be aired out.
And that
You
St.
look on-
Thomas Way gives access to a SEPTA. the
Yeah,
SEPTA
it gives
train.
access to a separate, on
It's back.
A6, you can see that it comes back and gives access to a separate driveway.
So can you put that on the table so the board?
Sure.
So we can see it?
Here's St. Thomas Way. Back here, there's SEPTA access, but that is an easement given to SEPTA by Villanova across Villanova property to access the SEPTA lot. It's an easement given to SEPTA along this driveway to access their parking on this side.
That was my next question. That is a formal easement, okay.
It's a recorded easement, yes.
Recorded, yes.
And as you see here, it comes back like this, goes that way. Here's St. Thomas Way, driveway this way, driveway that way. Yes.
Of course, yeah, once he's done, of course, absolutely.
And matter of fact, it's listed private drive on the plan itself. It's not listed on any of the township roads as a private road, as any right-of-way or anything of that nature. This is a driveway.
And Mr. Keneally, maybe this isn't the best plan, but this is the proposed plan, correct?
This is a proposed plan.
But that driveway in the rear currently exists, right?
Correct.
Going all the
Oh,
way
yes, all
across.
the way through, yes.
Over the lot line.
Yes, correct.
Okay, thank you. Counsel?
Just to return to the exception for adjacency to the CICD, and we talk about not being separated by roads, railroad property lines, which I can only assume was intended to be written without a comma there, not roads, railroad, comma, property lines. That's the way it appears on the general code. I think that's a really important question to be answered because there is a property line that runs all the way through. Whether they're not the public right-of-way or St. Thomas Way goes all the way through would be a different question. But I want to direct the board to the definition of street. And I concede openly that we're talking about the word road versus the word street. But the word street includes a strip of land, including the entire right-of-way, intended primarily as a means of vehicular and pedestrian travel, which may also be used to provide space for sewers, public utilities, shade trees, and sidewalks. The definition of street then has sub-definitions for half-street, public street, and private street. So when you talk about that parent, the umbrella definition, and again, we're drawing an equation here between street and road, but if you do make that leap from road to street, street includes public, private, and half-street. It includes any street. So I think to the extent we're looking for a definition or an understanding of what the word road means, I think that's the closest we have in the zoning ordinance, but I don't think it's a big leap to equate road and street. And that includes private rights-of-way.
Just to reiterate, this is not a road or a street, it's a driveway. And there's nothing in here that says driveway, nothing in here that says property lines.
So, yeah, Mr. Chair, I think I should withdraw the motion and perhaps move in smaller chunks
I think that's a good idea.
and see how the board goes.
So the
through
record will reflect that the motion by Mr. Weitzman is withdrawn.
But if any of the,
Maybe we should just vote on the motion then. Without, because maybe I do agree with that, because if the motion fails, then built into that is the idea that the Welcome Center didn't qualify as a permitted use, for instance, as an office use.
Okay?
So maybe we do leave my motion
Yeah.
intact.
Everybody is okay with leaving the current motion that's up on the, okay. Okay.
I like a double negative.
All right. Does any member of the panel have anything to add at this point?
I guess just, I don't buy that it's a driveway. If I can drive it, like, when somebody drives on my driveway, it's to my house, and that's it. The singular purpose is to my house. Whereas this, it seems like you can go multiple different directions, so it seems like it functions more like a road, but that's just kind of the layman interpretation I have of that.
The only question I would ask the board is whether or not, to me, a word that I focused on that clause was separated. Even if you accept St. Thomas as being a road or street, does it separate the two lots? Because I think there's another operative word in that sentence.
Okay.
Sorry,
All right.
but it does say that are not
Nick,
separated.
we
I'm
got the
sorry.
picture. Thanks. Okay, I'll call the vote.
I'm not in favor.
My vote's in favor.
I'm not in favor.
I'm not in favor.
I'm not in favor.
Okay, the motion is, or the appeal is denied. So by operation, Counselor, we do not reach the variance on the sign, is that right? Thank you.
Thank you for your time and courtesy.
Pardon me?
Thanks for your hard work.
We'll extend our condolences, extend our best to John, please.
Who excused the students? It's past their bedtime, I guess. I think what's going to happen is that they combine these lots, go to the township. They don't want to go to the commissioners for some reason. I don't know why, because I'm not that, maybe he knows. He's more tied to it. The next item on the agenda is Appeal 3220, Appeal number 3220. The applicant Brian and Deanna Galloway, property located at 9 Rodney Road, zoned R residential. The applicant seeks relief from 280-30E regarding rear yard setback and 280-32B for 10-foot separation from public building. This appeal was continued from the June 26, 2026 meeting. The applicant here?
Hi.
Hang on, just for a second. Let me get my papers all shuffled up here.
I was. Sure, it's Deanna, D-E-A-N-N-A, Galloway, G-A-L-L-O-W-A-Y.
Okay, thanks.
Thank you.
Oh, where the heck is-
It wasn't in the packet because it was continued. You probably don't have the file
No, I don't.
unless you see it.
Yeah, that saved it. It's probably at home, actually. Okay. Okay, have you been sworn in?
Yes, sir.
Okay, the last time, okay. All right, please proceed.
So, Mr. Chairman, members of the board, thank you for your time. We're here on a continuance from the June 2025 meeting to provide additional details about our proposed dining room and kitchen renovation. So, to recap, we are seeking to replace a current legacy 3-season room with a fully enclosed addition of an identical footprint, thus creating a dining room, which our current home does not have. Hence why I included some pictures as the exhibit. The current footprint of the room, excluding the staircase, which we will discuss later, encroaches on the 30-foot rear yard setback by 1.2 feet or 1 foot, 2.4 inches. I'm going to put this up here. This is the relief we seek from the rear setback requirement. This is also the size of the current structure that is there, and we feel anything smaller would really create a very dysfunctional room. In reference to that, the photos I handed out, I'm going to put this.
These are new, so let's go through each one of the exhibits, starting with photo number 2.
Okay.
Just describe what we're seeing.
Okay, so photo number 1 is in our 3-season room, and in this photo, my back is against the far wall. So it's basically showing that the room, it encroaches on the 30-foot rear yard setback by 1.2 feet. If this room was 1.2 feet smaller, it would be a really, really small room. We are renovating our kitchen. We don't have a dining room. That can be seen here. We're a family of 5. We have 3 growing kids, friends over, grandparents over, and this is where we eat all of our meals, at this little table with the built-in seats around it. And as you can imagine, seeing a giant 12-year-old boy climb around the table when his grandparents are over, it's a tight space. Our kitchen is also a tight space, as seen in the next photo. Photo 3. In photo 4, you can see how, this is the table right here. This is one of the chairs. That's how close the seating area is to the kitchen. And that just shows, just the table, and how when we have 6 people over, you can't really put anything on the table besides a casserole dish. Yes. So the
So
first,
I see that you encroach into the, just correct me if I'm wrong when I say this, you seek relief for the rear yard setback because it encroaches, what, 1 foot,
the exact measurement is 1 foot, 2.4 inches.
2.4 inches. Okay. Thought I had that. Oh, yeah.
Am I remembering this correctly? Wasn't there an issue with
Yeah.
the steps in relation to the garage?
Yes,
Okay. Is that still in front of us?
yes.
Okay, I feel like, you'll forgive me, that was June, that may as well have been 100 years
know.
ago.
So
I think the concern of the board at that time was, we didn't know what the
the
measurement.
concern was the exact measurement. So we do have the exact measurements for that now. Do you want me to just jump to that?
Yes.
Okay, so jumping to that, okay, so we had our engineer look at it, and he said the existing wood stairs feel structurally unstable and appear to be in disrepair, which they are. I've watched my husband fall down them. I've watched one of my kids fall down them. And we think that this really creates a hardship. So the stairs in their current position are in the setback. So in this, sorry, forgot the microphone was right in front of me. In this second exhibit, you can
Slide
see.
that more up towards the center so we can, there you go. Okay, thanks.
Okay. So where they are right now is right here. And as you can see, that puts the entire staircase into the 30-foot rear setback. What we're proposing is moving them to the eastern side of the house, thus moving them closer to the driveway, which makes it easier for my dad, who has a disability, to get in and out of our house. But it is also the issue is it is within 2.9 feet of our brick garage. And we know that there's like a 10-foot space between buildings on your property.
Okay, yeah, I think that's what we needed clarified, was it was 2 feet 9 inches. I don't know that we knew that last time. So if we could, just so that we have a clean record.
This
What's-
is new, so that we will need to make this into.
Oh, yeah, well, okay, so maybe we should mark this as an exhibit. Do we know what number?
Was this marked as
Well, that's-
Exhibit 2 last time? Because I see you say new exhibit number 2 on it.
These are all new.
Okay.
Do we
I
know?
just wrote on it new exhibit 2 because it was the second page that corresponded with my
problem.
notes.
Okay.
Yeah,
Okay.
okay, so that's fine, let's call it new exhibit 2.
Okay.
The record will be clean enough.
And to see on this too, because our architect did the measuring for this, and I feel like it's very confusing to see, but that space that I just highlighted, that's the 2.9 feet of relief that we're seeking. It's the bottom, it's portions of the bottom 3 stairs.
So really, the steps are 7 feet 3 inches from the corner of the garage.
Exactly.
Okay. And what's marked on this new exhibit 2 is wood steps. Those are existing, and your testimony is that those will be removed.
Yes, and also in doing so, this brick walkway is being eliminated. It's creating more grass in our yard. I mean, honestly, like, we all live in our homes. We carry groceries into our house. It's basically dumping me closer to the kitchen when I come in. But the biggest thing for us is it's a safer set of stairs. And if we can get them out of the backyard, which we know is already non-conforming, we would prefer to put them there.
Okay. We should probably mark the rest, what you handed up tonight. So new exhibit 2, we've established. There was a cover letter. I'm going to call that new exhibit 3. Is that fine?
I actually don't know what that is. I'm sorry. Oh, okay. That's,
Yeah. No. This one we're calling new exhibit 2 with the brick garage. Your engineer's report, new exhibit 3 then.
Yep, I'll put that up.
Okay, plus then the photographs. I didn't hear how they got marked. The packet of photographs, perhaps new exhibit 4.
Also, actually, I have, a new exhibit 4 should probably be the structural drawings from the engineering firm, because that shows them too.
I have this. Okay.
Do we make the photos 5 then? If you're done? We'll take the photos 5.
Okay.
New exhibit 5.
I mean, you don't really have to pour over the photos. It's just kind of to show that, like, it is, the back porch is a small room. We feel reducing it by that, even though it is literally less than 20 inches, it is going to make it very hard to get a table in the room that we can actually walk around. And with the stairs, I mean, we do feel very strongly that the stairs, it's a safety issue. We've lived here for close to 14 years. We have no intentions of moving. We love our neighborhood. All of our kids go to school in Radnor. I own a small business in Radnor. But these two asks would greatly improve our quality of life moving forward, especially as our family grows and as our kids get bigger and as we potentially have elderly parents living with us.
You want to move your exhibits into evidence? So they're moved.
What does that mean? You just say, please. Yes, please. Yeah.
I do have a question as well. I was reading through the engineering report, and what I was seeing is that the structure beneath it with this enclosed porch that you're looking to replace, the structure underneath is also insufficient.
Oh, yes.
According, so, okay. So there's a safety matter as
It's
well there.
we found out it's not even bracketed to our house.
That's what I was looking
And
at.
we've had like upwards of 10 to 15 people on it at a time at parties and
Okay.
stuff. Yeah.
So unsafe there, plus also the steps you were saying are also unsafe. Okay. Thank you.
Thank you.
I have a quick question for Kevin, actually. When measuring the distance from the buildings, is it at any point on the stairs that you measure it? Is it at the ends, or is it a percentage of the stairs need to be in the encroachment area? Just generally, how does one measure the encroachment?
The furthest most encroachment of the structure
Yeah.
across the setback line.
Okay. Yeah, I'm just trying to, does the majority of the stairs need to be in the encroachment area, or just at any point at all of the stairs?
Any point at all.
Okay.
And no portion of a structure can cross the setback line
Okay.
or be within that 10-foot setback.
Perfect,
In this
thank you.
case, it's just a portion of the staircase.
Okay, thank you so much.
What are you going to do with the area below this?
So we've actually gotten a couple different ideas because we're in the talk to contractors phase right now. We're probably going to pour footers. We might lay a slab underneath of it so we can use it for storage. But I don't know. It's just going to basically look nicer than what is currently there and not be sitting on 4x4s.
Yeah, thank you.
Any public comment?
Yeah, I just wanted, did you talk to your neighbors about the project? Did anybody express any objections or concerns?
Every single one of my neighbors said, that is going to be so wonderful.
Okay.
And it's in the original packet, too. We actually have signed letters from every single one of our contiguous neighbors and rear-facing neighbors.
Okay.
Can I have a motion, please?
I'll move that the Appeal 3220, requesting relief from 280-30E regarding setback and 280-32B for 10-foot separation from principal building be approved consistent with the exhibits and the testimony.
I'll second the motion. Any board discussion regarding the motion? Any call to vote?
I'm in favor.
Aye.
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 Okay, the motion passes. Thank you.
Thank you, gentlemen. Thank you for your time. It gave us some good time, too.
So you have all the stuff they used to. Yes. Anybody want to take a comfort break?
Yeah,
Okay.
it's always a good idea for old men.
Yeah, you go first.
I
We're going
will.
to take a 5-minute break. So reconvene at about 1:15. Yeah.
Next month, yeah, continue to October 16th.
Okay, the next item on the agenda was Appeal 3233, but that is continued to the October 16th hearing, zoning hearing. So that brings us to Appeal 3234, the applicant Michael and Lisa Murphy, property located at 146 Browning Lane and zoned R2 residential. Applicant seeks a variance from section 280-20E of the code to construct a sunroom on the back of their home and extend the roof over an existing patio, which is outside of the building envelope. Okay, go ahead.
Elizabeth Springer, Elizabeth, Springer, Springer.
Michael Murphy, Michael Murphy.
Can we have the microphone? The handheld microphone? The
I can use
handheld
this one too.
I don't see it. Just to make it easier to hear you. There you go.
Hello?
Hi, my name is Elizabeth Springer, and I am helping Mike Murphy as a civil engineer for the project. And we're here to request a continued, to continue to violate the rear setback. I have a plan that has been distributed to all of you, but I do have an update here. The only update to the plan is nothing with the zoning. It just shows a couple extra dimensions that Kevin asked me to put on the plan. So I can hand them to you when you're ready. And just, but otherwise, everything you have in front of you is correct. It's just that there was some dimensional information that might be helpful.
Okay, you want that part of the record, right? So mark it as an exhibit, or we can mark it as an exhibit.
Would you
We
like
can
it
hand
now?
up.
Would you like it now?
Yes, please.
Okay. You guys want 2, 3.
While we're doing that, I'm going to take your credit. We didn't see a copy of the deed or any authority.
I brought that with me. It took a long time for the homeowner to get it.
Okay.
So we finally got a hold of it, and I have all the copies of the deed as well. And this is all the copies of the deed, 10 copies. Sure. There you go. Okay, awesome. Okay, so the homeowner has had the land professionally surveyed, and so the information that we're building, we're building off of. Oh, sorry. Sorry about that. Okay, thank you. So in front of you first, you can reference SP1.
I'm sorry,
drawing-
there was only 2 pages to the deed that you handed up. Are there more? It was just the legal description and a signature page.
The information that was pulled was a packet, but those were the only 2 that referenced the information on the deed. It was like a,
And actually, this page, 12 of 12, looks like a mortgage to me.
yeah, the other pieces were just a mortgage paper, so I pulled out the part that referenced the property and the
Right, but
signatures.
I think for the application to proceed, we need proof of ownership, no?
The other was a mortgage application.
That was 13, I don't know, the 13 pages included the deed and the mortgage, because the bank.
Yeah, that was I pulled out the deed part of it.
guess, do you just want testimony?
What is the issue with getting a full deed? With the Mets and I mean, we had the legal description, but there's nothing else.
The rest was a mortgage document.
Well, it's part of a mortgage document, starts in paragraph 25 and goes to paragraph 27, but it really, I mean, is there some problem with getting a deed from Delaware County?
The bank owns it, we're still paying a mortgage.
Oh, yeah.
We're still paying a mortgage, so the bank owns the property and has the deed, and then they sent us a copy of what they had, and that's part of what we were sent from PenFed Bank. PenFed?
That's not quite the way, it's not like an auto title where the bank holds it.
No.
There's actually a deed that's in you and your wife's name that was recorded in Delaware County when you bought the house.
Right.
Okay,
And there's title insurance?
yes.
That's who you should call.
We could,
Kind of unusual.
if you, the board typically requires a deed. In fact, it is in our rules and procedures that you present a deed or some type of proof of ownership, which is typically a deed. Oh, I'm sorry.
Okay,
Well, we have two choices. One, we can, I'm pretty sure we can, perhaps move you over to the next meeting in October or November, give you time to get the deed. I mean, it's just unusual. I mean, lots of people have mortgages, but they get a deed when they go to closing.
I understood. I understand that. We can go
So
get the deed.
We just have a kind of a foggy thing here. I mean, you've spent money. I mean, you've had things surveyed and whatnot. The other option we have is that we could go forward, and you'd have to, on the record, you'd have to promise that you would produce this within a certain period of time. If we were to approve your application with the zoning relief,
What if we-
then you would have to present that within a relatively short period of time, or otherwise it would be a condition of the grant, and the grant would go away if you didn't give it to the township within the stipulated time period.
It would be lovely if we could present, only because it gives us an opportunity for everybody to hear the whole thing, and if there's anything else you need, it's a great opportunity to be complete if we do have to come back.
I think you're going to have to come back because of this problem with the deed.
I don't know that we're suggesting that you would come back on an open record.
Oh, yeah.
I
No.
think you would
Right.
present tonight.
We would love
We
to
would
present if
condition approval
possible.
on the deed being presented to the township within a certain
would be
amount of
wonderful
time
if we
to
could do
prove
that.
ownership, so.
Okay. Yeah, let's get on the record, though, the fact that you're the owner, and when did you bought it, and when did you buy it, and how long have you lived there, and so on. So we have some indicia of ownership. Do you get the
Okay.
real estate taxes?
Yes.
School taxes?
Yes, yeah.
That's certainly an
$12,000 a
indication.
year, yeah. Sure do. Yeah, we purchased the house in 2009. I've lived there for 16 years. We've done other work on the house in the past. So we did a renovation in 2011 and 12, and then we put in a patio where we had to file for something like this for impervious in 2015, so.
Well, your deed should be recorded in the courthouse and media, in the recorder of deeds office. I mean, you should be able to go right over there and get a copy.
Yeah, sorry, that was my fault. I don't know how that works. I sent an email to the bank and then sent me this 13-page document because I requested the deed, so I assumed it was the deed.
Okay.
It is. I'm learning a lot right now. This is
You can also get it online too as well. You don't have to go to media.
the deed?
Yes.
Oh, no kidding.
Just if it even saves you the trip.
Great. Wow. All right, I will do that.
All right. So let's start with the presentation.
Okay. Thank you. So The homeowner is requesting that they can maintain a rear setback nonconformity. The change in this is that if you look at the existing structure on SP1, the existing structure violates the rear setback yard because the building envelope of this particular lot is very long and narrow. So the house itself violates the rear setback. So you have two front yards in this particular property. So it's kind of unique. It's right on the intersection of Browning Lane and Meadowwood. And perfect. It's on the intersection of Browning Lane and Meadowwood. So here's Meadowwood and here's Browning Lane. And the house sits way back in the corner. So you've got a front yard here and you have a front yard here. So right away, because this lot is very similar to the sizes on Browning. Oh, well, let me pull it a little bit further into the camera then. Perfect. Okay, so this is the existing site plan pulled from the surveyor gave this to me. And this shows how you've got Meadowwood and Browning Lane. You have the house that's sitting back from the front yard setback and another front yard setback here. So that pushes the house into the back corner of the property. And in doing so, the setback lines are very, very narrow. So you have the whole half of the house, which is violating the rear setback. Okay? So the side yard setback is this one over here, and there's not a violation of the side yard setback, but the rear there is. And the structure in question is back in the corner. So if you go over to SP1, which is this one right here where my pen is, this is what would be our demo plan. So what are we taking off and what are we saving? So what we're proposing, and I have some photos to go along with it, which will really help you see the lot, but we're proposing that this structure back here, which is an enclosed sunroom, has an extension of the roof toward the rear, or excuse me, toward the side yard, which is this particular shaded area here, and that we can extend the roof as well toward the rear because the door exits on this side, and so we want to extend out to cover the door. So the cool thing about this is we're not increasing our impervious surface at all. And we're staying below the allowable building area. The allowable building is 18%. We're right now at 12.5, and we're proposing that the only increase is to building area because of the roof. So it's going from 12.5 to 13.4%. So we're still under the allowable building area. Our total allowable impervious is not changing because we're already have patio there. So we're not changing the total impervious for the property. What's also a little bit of a difficulty here is that it's hard to tell in this plan because it's ever so slight, but the house is cockeyed on the property. It's not actually flush with the rear property line. It's ever so slightly at an angle. So normally when we have situations like this and we have a non-conforming structure, we say, okay, what is the most protruding non-conformity on the rear thing? Well, it would be the chimney. But then when you actually take the measurements, which is why I gave you the drawing, you can see that there's an angle. By the time you get to the rear corner of this roof overhang, you're actually 18 inches closer to the property line than you were before because of the roof overhang. So you can't tell that by standing in the yard. You can't even tell it by looking at it at this scale. It's not till you pull a dimension line to it that you really can see that the house is ever so slightly tilted. So the whole rear yard is violated already. And what we'd like to do is rebuild that, not all of it, but rework that whole roof because of some issues that Mike can share with you in a moment. But I'd love to share with you some of the pictures so you can have a sense for who sees this and what is the impact to the neighborhood. I mean, first of all, no one can see this from the street.
When the house was originally built, it was built on this particular lot?
Yes, that's correct. This whole neighborhood was built in like 1950 to 1952, 53. And this is how they were all built on Meadowwood and Browning. And they're all really the same house. They're just I live on Browning, so I'm very familiar with the property. Okay, so in your original packet, you'll notice that there's some photographs. And we'll just walk through each one together. And we'll start with figure 1. So figure 1 is the view of the house from the Browning Lane side. So if you're standing here on Browning Lane at their driveway, this is what you see. And you can see the garage, and you can see the car parked in front of the main entrance to the home. But you cannot see anything in the rear yard. The vegetation does not allow you to see anything in that rear corner right here. So the trees and bushes that you see here are over here. And there's, when you look at figure 2, this is the house from the Meadowood side. So this is their other front yard. And you can see lots of vegetation. And on the right-hand side, you can see a 6-foot-tall fence. And that fence extends all the way to their property line and runs between them and their neighbor all the way to the back corner. So the fence is in this area here. If you look at figure number 3, you can see a view of 144 Browning Lane. That's their next door neighbor who would be to the left of them. And if you look at the figure number 4, you can see looking down their driveway across the street. So there's another corner lot there. So Meadowood and Browning have several corner lots there, because Browning is a horseshoe-shaped street, so there's 4 corner lots. They're really good pictures that you can see in figure 5 and 6. This is how, if you were to walk past the garage and down a little path, you would see the patio that Mike spoke about in the back left corner. So the side of the building there, that's the garage, and you're walking down the path into the back left corner of the property, which is this patio right here. So you really you can't even see it until you really get back there. So again, there's no view shed. And when you look at figure 6, this is the actual patio. Okay? There's a red arrow pointing to the structure under question. And what we'd like to do is take the roof of that structure and pull it out so that it covers a section right behind it. And you see that column right there with a light on it? That's where we want to drop the post for the roof. So that's the extent of it. So the measurements are on the next page. We'll get to that. But we only want to pull the roof of the structure out to create a little bit of an outdoor area that's covered. And then from the side, if you look at the next page of pictures, figure 7 and figure 8, you can see the red arrows that point to the side of the structure. And you can see there's no roof overhang there, but that's where the doors are. And we would like to pull that out 18 inches. And we need to rebuild that wall. So before we did any design at all, I pulled out the old permits for the project. And I looked at some of the photographs that were done, because I knew the person who lived in the house before, and I saw some photographs that were done during construction. And we know that we have to rebuild this one side wall because there's some structural and livability things that don't meet code today. This is the one in figure 8. So the sidewall, correct, the sidewall is, needs to be rebuilt to be able to put the new door in it. So I'd like to, and I need to put that as a 2x6 because I need to get the insulation value in. So that's what happens when structures like this are old. I can't tell the homeowner, well, sure, it's enclosed and you therefore it can do what you want it to do. No, we have to look at it to today's codes and today's structure and say, I can't recommend that you build on something that doesn't meet the code of how we would do things today. And so to get the insulation value, we need to put a 2x6 wall in, and that'll put the door in there. And we need to get the foundation right under the door because we can't see that the photos that were there actually presented a full foundation. So we're anticipating some structural fixes to that wall. So the roof would then overhang, which it should do on doors anyway. So when you're looking at this figure 9 and 10, those are just a few more pictures of the back patio, specifically figure 9 where you see the table, that's where we'll pull the roof above. So this is the area in which the roof comes over and covers the existing space. So again, the patio remains below. It's just that we need to pull the roof over. And on the side, we're going to rebuild the side wall to handle the door and the 2x6 framing. And then we're going to overhang the roof from there. So it'll come out a total of 18 inches, 12 of which is the roof overhang. I'll show you the proposed on SP2. So the SP1 demo and SP2 proposed site plan look very much the same because we're just showing where we're having, the roof is going to cover the patio. It shows you on the side where we need to overhang the roof and rebuild the wall, and it shows you on the back where we need to pull the roof out to create a little covered area where the table is. And again, no change to total impervious surface, a slight increase in building by rebuilding the side wall, and no increase to total impervious otherwise, but we are still going to be violating the rear setback. We have provided letters to the homeowner, and they're in your packet, and we have support from the homeowner who's on the Meadowood side and the Browning side, and there is a row of large evergreens on this particular property line, so you can't even see the house on Browning, and there's a 6-foot fence here, and the house sits pretty far off to the side, and the neighbors are both in support. And I think Mike wants to speak to the current structure and the livability.
Thanks,
Sorry,
Liz.
before you do that, I just want to ask a quick question. So the relief then is just to further encroach in the rear setback, right? The roof overhang on the side yard is not in front of us?
Well, the side yard setback is technically not violated because we have a side yard there. It's just that the whole back side of the house is in the rear setback. So.
Right, but the side yard, but you're proposing a roof over the side, correct?
The roof that's going over the side, yes, but I don't think that violates.
Okay, so the only relief tonight then is for the rear yard?
Correct, is just to be able to extend the roof 18 inches beyond where it is today, to be able to cover the door, provide some coverage over the door, and rebuild that side wall, so we have a total of 18-inch encroachment beyond what we have today.
Beyond what you already have,
Yeah.
I understand that, okay. But
And it's at an angle, so it's not 18 all the way, it's 18 when you get to the top back corner.
I
Otherwise, it's, you know.
Yeah, okay. Where I was confused in your presentation was one of the photographs shows a table and chairs, and you said the roof was going to come out and cover the table and chairs, but that strikes me as more than 18 inches, no?
Oh, right, that's the side yard. So that's not the part. I was just explaining the total project and the purpose of, it's a flat roof. So you know how you have with the drainage with flat roofs, like you need to be able to not have it running down the side of your walls.
Okay, so figure 9, I just want to make sure I'm looking at this right. Figure 9 is the opposite view of figure 6?
Yes, figure 9 and figure 6 are just two different
Just looking
viewpoints
at
from
it
the
from
same
the-
direction.
Okay.
The wall that is in violation is figure 8.
Right, okay, but, so we're not, okay. So the 18 inches isn't referencing 6 or 9?
No, it's just describing the total project and why the roof is coming out and just part of the big understanding of what we're doing.
Okay,
It's pulling the roof out.
thank you.
Yes, and so my understanding when we bought the house is that this room was kind of added haphazardly, without a lot of thought. It wasn't really finished. We put some flooring in, and then we learned that it leaked. There are skylights that leak, and it also leaks through that wall where the door is as well. So we haven't really been able to use the room too much to date, and so we spoke to Liz and started this project and feel like this will add a lot of structural integrity to the home and to the neighborhood, so.
Would you be able to elaborate more on the need for the 18-inch roof over? I know you said regarding rebuilding some of the structural matters regarding the wall, but what's the need here for that component?
Well, right now, when you hang the roofs over, if the water just runs down, so I do the structural plans as well, and I do a lot of structural inspections, and roofs, walls that don't have roof overhangs, especially over doors, they can create a lot of problems. So it's really nice to be able to cover your door. It's also great to not have doors where you have to rely on the flashing and you just really should have gutters and overhangs on everything. It also creates ice damming situations. It just gives protection. It's just part of construction that we give roof overhangs. And so by pulling it out, we're giving a little bit of protection to that door. It can be opened. We don't have to worry about the water leaking in. He has leaking problems on that wall. So we're just trying to give it a better structural integrity and typical building situations with roof overhangs.
Okay, thank you. So just to help prevent water infiltration?
Yeah, water infiltration
Okay.
and flashing and all the reasons that roofs leak when you don't have overhangs.
Okay, thanks for clarifying that.
Yeah.
Any other questions from the board? Public comment? Any public comment? Hearing none. Can I have a motion, please? Oh, I'm sorry, you didn't move your exhibits, that's right. And there's an additional exhibit, which is figure 14 and 15.
Yes, I provided you all with SP1 and SP2 that just had a couple extra dimensions on it to further clarify that the house was at an angle.
Got it.
But there's no change to the zoning tables.
So your exhibits are admitted.
And I even further clarified on, just so that you have one more, just to be extra careful, I want to make sure I cover all my bases. I just rewrote the zoning letter, the original introductory letter to you. It was slightly rewritten just to clarify. I didn't want it to seem ambiguous. Yes, we're still violating the rear, but I wanted it to be very clear with what we were violating it with. So I just updated the letter.
Okay. And that's number what? Did you put a number on that one?
I didn't,
I think your exhibits were lettered in your packet,
yes.
so you're replacing the brief narrative.
Yes, brief narrative, thank you, variance
So
letter.
that's Exhibit A, so it's just a new version of it.
Okay.
Yes, table of contents, thank you.
No problem.
All right. All right, so your exhibits are admitted. We call for public comment. Hearing none. Give a motion, please.
I'll make a motion here, so I'll take this one. So, Mr. Chairman, I will make a motion to approve appeal number 3234 in regards to a variance from section 280-20E of the code to reconstruct a sunroom on the back of the home and extend the roof over an existing patio. In accordance with the testimony and evidence presented, conditioned upon specifically the production of the satisfactory deed record.
Okay, do you want to put a time limit on that?
30 days? So that's reasonable? So, I think, is that reasonable? So, 30 days.
I'll second.
Any board discussion? Okay, I'll call the vote.
I'm in favor.
Aye.
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 Okay, there you go. Thank you very much. Nice to see you again.
Appreciate it, thanks, John. Thank you.
Just throw this one back. Okay, the next item on the agenda is Appeal 3236, the applicant Donna M. and Scott Wilkins, property located at 288 Hares Lane, zoned R1 residential. The applicant seeks a variance from section 280-14 of the code to permit an additional dwelling unit with a full kitchen conditioned on the above expressed limitation. Applicant further contends that the use is permitted under the Fair Housing Act 42 USC Section 36 04, small b in parens, and the Religious Land Use and Institutionalization Persons Act 42 USC Section 2000 CC, which forbids land use regulations which discriminate against religion and required reasonable accommodations on the part of municipalities. In the alternative, the applicant requests such other relief consistent with the exhibits and testimony presented at the zoning hearing.
Evening, Nick Cornelia, representing the applicant. And thanks, John. It is relatively simple application after, when we go through all this.
Yes.
So the Elkins recently purchased this property, and actually there's a misspelling in the notice. It's Elkins and not Wilkins. I think I know the application says Elkins, but I think it was just probably a typo.
What's the proper spell? What is the proper-
Elkins.
Elkins. Got it. Okay, thanks.
And they brought the house recently. It had actually a full apartment. The issue isn't the living space, as Kevin can testify to. It's a full kitchen. The full kitchen includes an oven. When they bought it, it did have an oven in it. They have since rehabbed it, got permits, taken the oven out, and then, of course, making this application to reinstall the oven. With the application, you'll notice that I've attached a proposed restriction, a deed restriction that would run against the property, preventing the apartment from ever being rented or used for commercial gain of any sort. And of course, it would be subject to the solicitor's approval. And obviously, before we file for a building permit, we would have to record that and present a copy of it to the township so that it would show the restriction on it. The main purpose of this is to have a kosher oven in the premises. But again, as I said, I think it's up to the board. I believe he's entitled to it under the Religious Freedom Act. But again, I believe that we can probably just rectify this by giving a variance or other relief that may be required by the board to make it easier if the board would prefer going that route rather than employing the Fair Housing Act or the Religious Freedom Act. According to both of those, the reasonable accommodations have to be made, and the reasonable accommodation would probably be the granting of a variance. So, I swear in Scott.
I do. And would you say your full name and spelling? Scott Elkins, S-C-O-T-T-E-L-K-I-N-S.
And Scott, where do you reside?
288 Hares Lane.
And who do you live there with?
My wife, Donna.
And I'm going to show you what's been marked as A2. And is this a copy of your deed?
Yes, sir.
And it indicates that it was purchased on June 19th of 2024.
Yes.
I'm next going to show you what's been marked as A3. And this is a site plan of your property. We have some photos that'll better show the property, but this is a copy of the site plan. And actually, if we show A4, is this the area surrounding your property?
Yes.
And that little star there is where your property is located.
Yes.
What's this big mass that's in front of it?
It's the Radnor Corporate Center.
Okay.
Or Financial Center.
All right. And I'm going to show you what's been marked as A5, and this shows your property. And I'll put it next to the site plan, if we may. And where is the apartment? Where is it currently located, and where are you proposing to place the kitchen?
So the kitchen is already existing in the property. It's over the garage, which is right here.
And that garage backs up to where?
It backs up to a driveway going down to two homes that were built at the bottom of the original property.
There, is that correct?
Yes.
And the corporate center is located where, if you're looking at A5?
The corporate center is here.
So actually, and where did you mention that the accessory structure is?
Here.
So actually, the closest neighbor is the corporate center.
Correct.
Now, showing you what's been marked as, what would you say the distance is from probably your nearest residential neighbor to where the apartment is located?
They're here, 100 yards, 50 yards? 50 or 100 yards? Yes.
And how large is your property?
4.5 acres.
Okay. And showing A6, is this the kitchen when you purchased it as it existed then?
Yes.
And what have you done? Have you done anything to this area? Again,
Yeah.
this is on top of, would it be the garage?
Yes,
or-
it's on top of the garage.
And what, if anything, and that's attached to the home though, right, by a breezeway?
It's attached by a breezeway, yes.
And,
By a breezeway.
and if you could describe what A6 represents.
Sure, so A6 is the apartment when we purchased the home. It had a full kitchen. In renovating different portions of the home, we decided to renovate the apartment next. We brought a contractor over who brought an inspector over and said, what are you doing? We told him we were simply removing everything in place and replacing it. So new floors, new appliances, new bathroom tile, new fixtures, not moving walls, nothing else beyond that. And the inspector said, that's great, but that oven can't be there. And that's the first time I heard that you can't have a second oven in the township. I had no idea, obviously. When we bought the house, it was there. So we've since applied for a permit. We've done all the work. We have not done a kitchen, obviously, the oven. And we hope to obtain a variance and ultimately put an oven in.
I'm going to show you what's been marked as A7. And can you describe what A7 represents?
Yeah, so A7 shows two things. It shows the apartment on the right side where I'm pointing to now. Yes, the apartment on the right side. Bedroom, a living area, a small dining area, and here's the kitchen that we just saw in the previous exhibit. And over here, for some reason, is also the second floor of the house. I don't know exactly why they're on the same plan. But.
Is there a reason why you're requesting a full kitchen, a second full kitchen?
Yeah, there's a couple of reasons why. I mean, obviously, we've got an apartment there. We expected when we replaced all the appliances and replaced everything else, we replaced the kitchen as well. When we bought the house, we saw it there, and that was one of the things that enticed us about the home. I'm sorry. It was one of the things that enticed us about the home, that it had a second apartment and an apartment and a separate kitchen. And the second was it gives us an opportunity to observe kosher law if we should so choose to do.
Have you agreed to restrict the property, as I mentioned in opening?
Yes, 100%. We have no intention in any way, shape, or form of renting, subleasing, or using this property for any type of economic gain whatsoever.
And is A10 a copy of a restriction that you're willing to place on the property and have recorded?
100%.
And just by note, I think Mr. Rice had provided me previously in a similar matter this type of restriction. It was a little bit different, but this type of restriction. So I kind of used the same form and just filled it in as to the particular circumstances in this case. And that's where the restriction
What is
comes
the
from.
exhibit for the,
A10.
just not finding it in the pile of exhibits, just give me a second.
There you go, John. You want to look at it?
Oh, there's, okay, got it. So you were asked just to remove the oven, nothing else?
Yes.
the oven, this is where the oven, and again, Kevin can confirm this, the oven makes it determined to be a second living unit. And actually, that's different treats it the same way as you do, Kevin, so.
That is correct. They can have an accessory unit or structure there, and it can be used for a variety of different uses. It's the second kitchen is what determines a dwelling unit per our code.
But it's not deemed to be a second kitchen unless it has an oven.
It's not deemed to be a dwelling unit unless it has a kitchen, and a dwelling unit is defined as having a full kitchen.
Got it.
So you can have everything but the oven.
How about a microwave?
You can have a microwave. You can have a convection, I think you can have a convection oven, can't you? No?
Stoves, ovens, and ranges are prohibited.
Okay.
The people you bought it from, did they have was it an in-laws place, or what did they use it for?
I do not know. It was not in perfect condition when we bought it, so it looked like it hadn't been used in a while, but I don't know.
In the restriction, paragraph 7 deals with the dwelling use restrictions for this particular item, and paragraph 9, of course, makes it run with the land. So it's just not personal to this applicant. It would run with the land in perpetuity. And then A8 and A9, I had just attached the codes, and I had done a memo, I'm sure that you've probably seen it, regarding the right to use it.
Nick, could I ask for some more testimony on the religious aspect
Sure.
of it? Mr. Hawkins just made a comment that if we choose to, do you maintain a kosher home currently?
We do not.
Will you or could you maintain one in the future?
Absolutely.
Would you need a second oven to maintain a kosher home?
So the laws on that, as you may know, are complicated. It certainly makes it much easier. You technically do not need or require, but it is not only customary, but it is custom and practice to have one.
This would enable you to maintain separate plates, separate utensils, and so on.
Yes.
Could you explain the Religious Freedom Act and the implications of that on this?
The Religious Freedom Act provides that you may practice religion freely, obviously. But what it states is that basically the least restriction. So in order to practice that freely, the township is required to approve items under their current law. In this example, it would be as a result of the granting of a variance under the Religious Freedom Act, just like in the Fair Housing Act, similar type as far as the statute's concerned. As I said, I believe you should have the memo in your file that further explains it. And we certainly can go through it if the board wishes.
I think I'm all right. Thank you, Nick.
Okay. But remember, I believe in the past this board has approved in-law suites and things of that nature. And we're even going a step further here. We're going to deed restrict it so that there can't be any qualms about it. That's what we're intending to do.
Any other questions from the board? Any public comment? And you've discussed this with your nearest neighbors?
I have, yes.
Okay. Yeah, can I have a motion, please?
So we'll do the motion for appeal number 3236. The applicant Donna M. and Scott R. Elkins, property located at 288 Hares Lane and zoned R1 residential. The applicant seeks a variance for section 280-14 of the code to permit an additional dwelling unit with a full kitchen conditioned on the above express limitation. Applicant further contends that this permitted under the Fair Housing Act, section 42 USC, section 306-4B, and the Religious Land Use and Institutionalized Persons Act, 42 USC, section 2000 CC, which forbids land use regulations which discriminate against religions, required reasonable accommodations on part of municipalities. In the alternative, applicant requests such other reliefs consistent with the exhibits and testimony presented at the hearing, also conditioned on the deed that confirms that this is going to be limited to non-commercial use tied to the property.
Second.
I'm in favor.
I'm opposed.
Yay.
Yay.
Thank you. Thanks. Thank you. Anywhere?
I have another case. So you're good. It's just, yeah.
Well, this,
I know.
there's a bunch of people that have violated this in the township. But it's like, I built an in-law quarters on my house and sold everything to my daughter, and we live in the in-law quarters. There's no oven. But we have an air fryer, and we have one of those microwave convection. Yeah. The big thing is you gotta have the dishwasher. Because one of the other things, look at the old mansions, and then they had gatehouses. And that's been where I've seen this before, was that yeah, you live in a nice big old mansion, and beautiful gatehouse. They can't do anything with it.
How often are they splitting the lots? Are they splitting those lots that have the kind of gatehouse further away from the building? Or is it usually too small of a lot to split the lot?
There's usually, when they cut them up in the old days, they weren't, either it wasn't a requirement or they just didn't think. So the gatehouse usually is on the same lot as the main house. There's a couple near us where the gatehouse is way down here and the big house is up there, so they just chopped it up and left a little itty bitty lot. Are you back again? Gee.
Yes, 3237.
That's right.
Just for the record, I went to an Augustinian high school. I know a lot of those guys are planted on the hills.
Did you go to Malvern? John, did you go to Malvern?
No, I wasn't, no, I went to Monsieur Bonner.
Oh, you went to Bonner, oh. I'm sorry, I didn't mean to.
No, it's easier for me to go to Bonner.
They may have a saint soon, too. They may have a saint soon also. They're pushing for Father Atkinson to be canonized.
Oh, really?
Yeah,
Oh, yeah. I knew a bunch of those guys, that's for sure.
yeah.
Alfred E. Smith III, who looked just like the original Alfred E. Smith.
Really?
Alfred E. Smith, the governor of New York. It might have been, yeah, the governor of New York. And,
Yeah.
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 Governor of New York. And, yeah.
Yeah.
That's been, yeah.
Yeah.
That's
next item on the agenda is Appeal 3237. The applicant, 150-158 East Lancaster Partners LLC, property located at 150-168 East Lancaster Avenue and zoned WBOD. The applicant seeks variances from section 280-53-12 of the code relating to the number of required off-street parking spaces, and section 280-53-7 relating to the use regulations for a studio use which combines athletics and learning classes for children and for a Pilates studio, both of which are similar to the prior karate studio, which occupied a portion of the premises. In the alternative, applicant requests such other relief consistent with the exhibits and testimony presented at the zoning hearing.
Good evening, Nick Cornelia, representing the applicant. You're familiar with this project. You've seen it before, or several of you have seen it before. This is the corner of Luella and Lancaster. What you're looking at here, that I'm showing you that's been marked as an exhibit that I just handed up, is the old site with the retail uses on the storefront and the apartments up top here in this area. And you'll notice it had Pliables, Integrity, Nail Salon, a French bakery, a Marshall Fitness, which is similar to the uses that were being proposed here as well. I believe it used to be a print shop. Matt Johnson can testify as to what it is or what it was at that time. This is the proposal. You may recall there are apartments on the top, on the second and third floor. All the apartments are being provided for by parking underneath the building. So the only requests that we're making here regarding parking and the use is for the portion on the first floor. And you'll notice on this exhibit, again, we've marked it and we'll reference it during the presentation, that we have a restaurant at Unit A in this location here. We have the indoor recreation units. One is a Pilates studio, and the other one is really a kids' gymnasium. We'll get into more detail on that, but it's a gym really for children, young preschool children, as well as school children. For the preschool children, you'll have the mother or father there with them. They will be doing certain things that involve exercise as well as learning. And then in the afternoons, when the kids come from the middle school, possibly to go there as well for some sort of recreation being involved. So that is geared to children. There's also a Pilates studio. I think we all know what is occurring with Pilates now and with exercise and things of that nature. You'll hear testimony that really Wayne now is a difficult place to lease space to, I think, as you're all aware. It appears as if really the only ones that are really looking for space now are restaurants and some type of fitness facilities. And that's what we've seen, and this is what you're hearing testimony about this evening. So we're going to have several witnesses. One's Matt Johnson from Berger, who's testified here previously on the original project. The other one's Jason Bach, who's a broker involved in renting this space and specializing in development projects. Then we have the operators of the Little Gym and the Pilates studio, and then Frank Tavani will talk about parking and traffic implications. So, Matt?
Nick, before you get started, can I ask you an overarching question?
Yes.
I'm just curious because I went back and I was glad that you included our decision when we granted this, but we granted parking relief as part of what was given.
Yeah.
So why are you here tonight?
Okay, so the first time that we granted parking relief, actually there was an existing nonconformity. We actually reduced that nonconformity by what was being proposed here. But we still had to come in and ask for the relief for that, even though we're reducing the nonconformity, because the way the parking code is now being interpreted, anytime you come in for parking, you have to ask for it. What has happened now, since it was built and started to be marketed, we found out that these certain uses are not really relevant or feasible anymore. So the reason for the parking relief now is because we found out that at least the code requirements for the parking for the uses that are feasible to be putting in here is greater than what you previously granted relief for.
Is that because of the restaurant being proposed?
Part of it is the restaurant, and part is because of the fitness facilities too.
Okay.
Because the fitness facilities actually require one space per 150 square feet. So it's a pretty stringent code requirement. But it's also, you're right, it's also partly because of the restaurant as well.
Right, because really, I mean, when I read our opinion, it seemed like we agreed that it was 10,000 square feet of retail space
Yeah.
that needed some parking
Yeah.
relief.
And it is still 10,000 square feet of retail space. That space has not changed.
So why do you need, so that's what I'm wondering.
okay, yeah,
Is it
because-
because of the categories
Yeah,
involved?
yes, because if
We
it's straight.
painted with too broad of a brush.
Yeah, because if you're just talking straight retail, it's one space per 200 square feet. If you're talking indoor recreation, this is being treated as indoor recreation, even, I think an argument could be made as a personal service, but it's being treated as indoor recreation, that's one space per 150 square feet. Then, of course, with the restaurant use, it's one space per 3 seats, plus one space for every 2 employees. So really, it's because of what we found out from the marketing standpoint of what we're going to be required to put in there that we're now asking for the parking relief as well.
So the breadth of our variance,
Didn't,
23 doesn't,
doesn't cover it, yeah.
Did
Yeah.
you actually have leases for a
Yes.
restaurant and
We have leases.
Mitchell Eyewear or whatever that is?
Yeah, we have leases and LOIs. I can hand those up if you want. They're not part of the packet right now, but I can hand those up if you wish. And just the other thing, that the exhibits I handed up to the board, it starts with A8. A8 is the same parking study, or at least the analysis, and it's the same parking study. When we reviewed it prior to this hearing, we saw that we duplicated page 5 twice. So the only reason that we changed A8 is we put the real page 3 in, because previously page 5 was both page 3 and page 5. So all we did was replace the real page 3 that was listed as page 5 with the real page 3. They follow me? Yeah. And that's the only change. And then A9 is a floor plan, and actually, with the submittal, we had a floor plan A7, and Kevin asked for a more detailed floor plan, and we provided that, and that's now listed as A9. So A9 is really the floor plan, not A7. And then A10, these are new exhibits, and that would be, A10 would be the existing site. Yeah, A10 is actually 2 pages. One, the proposed building, and the existing building was A10. A11 and A12 are 2 letters of support from neighbors that live on Midland Avenue. And you'll see their level of support is, these are the type of uses that people can walk to. These are the type of uses they see that are beneficial to the neighbors and the occupants of Wayne. Okay, Matt? And did I miss a question that someone asked and I jumped to something else, I think? Did I get it? Okay. Matt, what's your relationship to the applicant Berger Development?
I am employed by Burger Development. I'm the Vice President of Real Estate Development for Burger Development.
And were you previously involved with this project?
Yes, I have been working on this project since Burger purchased the property in 2022.
And from the beginning of the project, actually, you've been kind of the lead guy.
That's correct.
With the township. Okay.
Yes.
A2, that's the deed to the property?
Yes.
Okay. Can you describe the former site? And I'm showing you, where's the, we have the,
Sure. It's
where's the, we have the, yeah. And this is marked, there's 2 pages I said that was marked as A10, and this is the before photo of that. Can you describe the prior uses that were, the prior retail type uses that were there previously?
Sure. The previous building had approximately a 10,000 square foot footprint. It included approximately 10,000 square feet of retail on the first floor, which was at grade with Lancaster Avenue. The second floor included 9 apartments. The third floor, which is, you can see up here, this was vacant. And then there was a basement level underneath the entire building. And actually, one of the retail tenants on the end, they actually also utilized the basement area. That's here with the pink awning labeled as Gingy's. The prior retail tenants, just going from left to right, it was Gingy's, which was a clothing store. It was the martial art studio labeled Pro Martial Fit. Then it was the bakery, the nail and spa salon, Integrity Eyeglasses, and Playa Bowls, the smoothie salad store. So.
And have you increased that retail, what we'll call retail area, that first floor area with the proposed development?
We actually have less leasable area in the new development than we had in the previous development.
Did that previous development provide any off-street parking at all?
There was no off-street parking on the site previously. There were 18 on-street parking spaces. There are 10, you can clearly see them in front of the building, but there are 10 out on Lancaster and 8 as you go down Luella.
And are they being preserved? After the construction's completed, will they be reinstalled?
Yes, the locations of them will be slightly adjusted, but we will maintain the 18 street parking spaces that were there previously.
And the other part of A10, is that the proposed plan,
Yes.
rendering?
Yes.
And can you describe, again, where the particular retail uses are going to be located? And we're going to have a lot more testimony on the uses themselves and the hours of operation and the number of seats and all that. But if you could just describe where they're going and give a brief overview of what they are.
Sure. So what you're looking at on the screen is you can see a three-level building. There's actually a basement level below this, which you can't see on the screen. And the basement level, that's where the on-site parking will be. Level 1, which you see on the screen, which is at grade with Lancaster Avenue, that's where all of the retail tenants will be. The corner retail space is meant to be a restaurant. It's labeled Unit A. The second, where it says visual eyewear and the next storefront, that's Unit BC, the indoor recreation use. That's going to be the Pilates studio. And where it says wine collection in the rendering, that's the other indoor recreation use. That's the little gym, the children's gym. The last storefront, that would be the entrance and the stairs that get you up to the 2 levels of apartments above.
Okay, so the visual eyewear and the wine collection, they're not there.
That's correct.
Okay. Just A3 currently is undergoing construction. A3 kind of at least taken probably a while ago, but the start of the construction.
Yes, A3 is a photo of the construction as of probably 2.5 months ago. At this point, we have footings and foundations in and 2 levels of steel up.
And A4 is the prior zoning decision where we asked for relief on parking, and there was some relief also granted regarding setbacks, I believe.
That's
A4?
correct.
Okay. And you did proceed with land development for the township, and you received land development approval, and that's been marked as A5.
Yes.
Now, I'm going to show you, well, also, while we're looking at this plan, did the applicant agree to do certain improvements? You mentioned the parking, reinstalling the parking, the on-street parking.
That's correct. So we're reinstalling the on-street parking. All of the sidewalk parking spaces, that will all be new. We're also installing a stormwater basin to handle the stormwater from our site. Previously, there was no consideration for the stormwater from our site. It just all ran off and into the sewer system. But we're installing a system to handle that and manage it and kind of release it more slowly. Yes.
Okay. What happened? As you heard Mr. Weissman said, what happened that all of a sudden we're back here again?
Sure. So our original variance approval and what we presented when we received that variance approval, we presented 10,000 square feet of retail. The retail parking ratio, is this the old plan or the, yeah. The retail parking ratio that we had previously presented was 1 space for every 300 square feet. Because the uses that we have leases for and LOIs are not considered retail in the zoning code, they're considered, it's a restaurant use and the indoor recreation. That has a higher parking requirement than the retail we had presented previously. So previously, we presented a parking deficit of 32.7 spaces, but given the uses that we are proposing for the site, our parking deficit currently will be 78.7 spaces.
And just to go through, because I think I had quoted a space per 200, but I think in the WBOD, the retail requirement is 1 per 300. In the other, correct, item? On the, I'll look at the code.
I have it.
I don't want to put you on.
No, I have it open. I anticipated some questions on the parking.
The WBOD, Matt just testified that they had used 1 per 300 for the retail previously. During opening, I had mentioned 1 per 200. So actually,
It is 1 per 300
it's
for
1 per
retail.
300. 1 per 200 is in other sections of the township, not the WBOD. So that was my error. Just want to point that out to the board. 1 per 300 is the requirement for retail, and that exacerbated because of none of that 1 per 300 is being applied here. And again, Matt can go through the issues they've had, as will other witnesses. So what's being applied here is the restaurant use, which is 1 per 3, plus 1 for every 2 employees at peak employment. And you'll see on A6, we're listing 10 employees, I believe. And then on the indoor rec, which is the little gym and the Pilates studio, the requirement is 1 per 150. So that's the difference. That's why we're back. And again, Matt, what caused that? I mean, once you went out marketing, did you find, now other witnesses will testify to it also, but if you just give it.
Yes, we engaged Jason Bach with MSC in October of 2023, I believe. So they've been marketing the project for about the past 2 years. The tenants that we have gained interest from were primarily restaurants, coffee shops, fitness uses, and similar uses. So given the lack of interest from pure retail, which would qualify for the 1 for 300 parking ratio, that's why we're back, because the uses that we gained interest from require the greater parking ratio. And then also, two of the uses are uses that are not or not defined to be allowed in the WBOD with the indoor recreation.
Now, I'm going to show you what's been marked as A9, and remember this replaced A7 for the floor plan. And can you tell the board what that represents?
Sure. So we're looking at the retail level plan, the ground floor plan, which is that grade with Lancaster, and you can see the restaurant on the corner, which is labeled at Restaurant Unit A for about 2,800 square feet. The center space, indoor recreation, Unit BC, that's what I had previously said will be the Pilates studio. And then on the left-hand side, indoor recreation Unit D is the little gym, the children's gymnastics tenant.
Okay, we know there's a lot of restaurant uses in the WBOD, but the other uses, the indoor recreation uses, do they currently exist in other areas of the WBOD? Just to show consistency with these uses compared to the locale.
Yes, so if you recall, the first image that we presented was the previous building, and we had a karate studio in the previous building, which I believe to be a similar use. Also, just in our quick look around the WBOD, there are yoga studios, and there's a baseball training facility, and there's fitness studios, which offer both personal training, but then they also offer classes very similar to classes and boot camps, very similar to what would be going on in the Pilates studio and the children's gymnastics lessons. So.
Okay, that's all I have for Matt. Any questions? I'm sorry.
Just to get it sorted in my head, what was the original and approved number of spaces, and how many do you need now?
The original nonconformity was 43.1. The original approved by the variance was 32.7. Remember, as I mentioned, we reduced the nonconformity.
So,
go ahead.
I'll further. The old building had a requirement for 43.1 spaces, and there was no on-site parking. When we were first here for a variance, what we showed as our nonconformity was 32.7 spaces. So we actually showed the nonconformity coming down from the existing 43. Now the nonconformity is 78.7 spaces.
Thank you.
We have two levels of apartments, total 24 units. The parking ratio for apartments is 1 for every apartment less than 800 square feet and 2 for every apartment greater than 800 square feet. We have 4 apartments greater than 800 square feet and 20 less than 800 square feet. So it requires 28 spaces for the apartments, and we have 28 spaces in our basement level garage.
And therefore, I'm assuming that the parking that's below grade, that's strictly reserved for the residents.
That's correct.
Right. Thank you.
Yeah.
Okay.
Jason? I know what it was. Mr. Lord, John, you asked for LOIs and leases. And I know I have them here somewhere. Here it is. Can I mark them all as one, or do you want them? Okay. I'll mark A13 will be the LOIs and the leases, and the lease. The leases with the restaurant, the LOIs are with the other two. Okay, Jason, I'm sorry.
I do. Jason Bach, B-O-C-K.
Jason,
Okay.
Ja- Jason, what's your profession?
I'm a commercial real estate broker and represent national and local retail tenants and developers in the area to help fill the retail space throughout the region and throughout multiple states in the area as well. I'm a local Radnor graduate. I've lived in Radnor for 10 or so years. Moved here after college, after the city, so I know Radnor very well. Won a state championship at Radnor High School, actually, in hockey. So yeah, Radnor's home base to me. One of the reasons I took on this project with Burger Development is because I wanted to see something in downtown Wayne, which Wayne really needed and really wanted. I didn't want to see the nationals like the Chipotle's or the Starbucks or the Rita's Water Ice. I wanted something a little more characteristic here that really shared what Burger Development's doing with the building. So we really try to strive to get the absolute best tenants here possible. We could talk about that a little bit further as well.
So how long have you been marketing this site?
We started about 2.5 years ago. We know it takes a while to get the best tenants, come to these centers and these spaces rather. There's not a lot of retail here at all. It's a little small development, so we really tried to get the best piece possible and the best tenants here. It's been about 2 years. There hasn't been a ton of interest on. We really wanted to fill this space before the building was completed, so there was no vacancy along Lancaster Avenue right there. There's other older buildings with vacant windows and whatnot, so we really strive to have all the leases done before groundbreaking, which we're close to, but more importantly, all the leases in the space filled when the residents were moving in, the building was finalized, which will be in April is when the retail space will be delivered to the tenants. They're going to build out for probably a fall opening and a fall moving in of some of the tenants upstairs. So throughout the past couple of years, we've had a lot of restaurant use really active in the interest there. A lot of restaurant use that was bigger as well, 6,000, 7,000, 8,000 square feet, and Burger really said that we don't want that. We don't want that many people here. We want something small. So we really strive to keep it under 5,000 feet, under 4,000 feet. And we actually got the restaurant down to 2,800 feet, which was a pretty big success with having, back of house staff and there's no outdoor storage, all the trash is inside. There's other things like that with the indoor coolers. So the space is even smaller than it really shows on paper of 2,800 feet, the actual dining room. And then with the other uses, the gym use and the little gym for kids really help each other with regard to timing and time management throughout the day. Obviously, the restaurant use is 5:30 to about 9:30 at night, Wednesday through Saturday. In the first couple years, start opening for brunch on weekends and things like that. But the gym will speak and the Pilates studios will speak as well. It really offsets timing of congestion of the area and of the actual project itself. So we really try to help the design team of Burger go through that process and not have the same day part, all restaurants, all nighttime use, all lunch use, all morning use. So everything kind of caters to different times throughout the day, which we're pretty happy about, and we thought that was a pretty good use for the overall building and the residents above.
Do you have difficulty finding uses that were permitted by the WBOD? Basic retail uses such as
we did.
Clothes and...
Yeah, nothing is really by right, obviously, and retail is such a vast word. It goes, I think retail is anything that would fill a shopping center, anything someone would go to shop. A gym is retail. Now medical is retail. We're putting hospitals into shopping centers. We're putting office buildings. We're putting accounting offices. All of this is now retail. Because of COVID, everything changed. So it really was difficult finding straight retail by code to go here. And those are also maybe, a mom and pop or someone who would go out year 2 and you build this beautiful building. Next thing you know, you have a vacancy a year or so later. So it was really challenging finding the right tenants who could support a brand new project like this and to come in. And also the space isn't that big. You can see we sort of work with each tenant specifically to move the walls and really cater to each tenant what their needs were. So we're really happy to come in front of the board here and show that all the retail is actually fully leased up and we have all leases basically done and all tenants here are represented. So the building's 100% complete.
Let's talk a little bit about the restaurant use. Can you describe the type of use and the type of restaurant it's going to be?
Correct. So it's going to be a small boutique steakhouse. They're really coming away from the larger Del Frisco's of the world and the Capitol Grill. It's a real kind of family style high-end steakhouse. It's a real small concept. It's going to be an open kitchen, open floor plate, 10 seats at the bar, around 60 or so seats inside. So it's really, they want it to be small, like I said, about 2,800 feet. So you could lease it out or rent the whole thing out for a graduation party or, you know, a high school party or 16th party or 21st birthday for, you know, the parents are doing it. It's going to be an expensive steakhouse, expensive high-end restaurant. So they're trying to take, you know, the clientele from the main line and really cater to that, but very low-key. It's not going to have a real bar business. It's just going to offer some drinks, obviously, with dinner. It closes about 9:30, but it's really chef-driven, kind of farm-to-table, dry-aged steaks, and all shared meals and things like that, but not for your college students or things like that. It's a high-end plate, a high-end ticket.
And I believe what we show on the parking summary is 80 seats, well, 90 seats, but 10 of them, I believe, are at a bar, as you mentioned, I believe, 80 or the dining area, according to the parking summary.
Yeah, it's about 60, 65 seats. There's going to be a chef table of about 10, then a bar around 10 as well. But it's going to be free-flowing, so we can move the tables around for larger parties. As mentioned, we think there's going to be a lot of, you know, graduation parties and business dinners. We really want to cater to Radnor Business Center and things like that. We think that there's kind of a void for that kind of use around here in this small boutique feel where you could walk from the neighbors' houses around, from the businesses in downtown Wayne. So that's what really the boutique restaurant is catering to that genre.
And the peak number of employees?
It's going to be 10, and that's probably at the absolute most. There's going to be about 4 or 5 servers. There's going to be about 4 back of house. There's going to be prep, but prep's going to be out of there by, you know, 2:30, 3 o'clock. So at the absolute greatest, it's going to be 10, but probably should be around 7 to 8 employees.
How about hours of operation?
Hours of operation are from Wednesday through Saturday, 5:30 to about 9:30. There's going to be about 1 seating Wednesday, Thursday, Friday, probably Saturday, probably 2 seatings. We're going to try to get in there an early seating and a later seating. Probably 6 months in or so, open for brunch on weekends and Saturday, Sunday brunch, and then take it from there. So it's really a dinner focused, and that's one of the things we like with the other retail here. It opens up the rest of the space for the other traffic with the other hours throughout the businesses.
Your anticipated busiest times?
Probably weekend evenings, dinner time around like things like that. But there's going to be a lot of walking traffic. There's going to be everything with the furniture store open up next door, and which also helps with parking. They don't have a lot of parking use right there. But we think a lot of the neighborhood residents will come out here, grab a quick drink in the bar, grab dinner, things like that. So we think it's going to be a weekend, Saturday, Friday, Saturday evening.
Okay, thank you. That's all I have for Jason.
Thank you.
Thank you. Do the little gym?
Nick.
You raise your right hand. You swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
State your full name, please.
Nicholas Markley,
Spell your last name.
Markley. First name is Niklas.
Nicholas, what's your involvement with the little gym?
I represent the tenant broker in the transaction. I'm also the master broker for the Little Gym, helping all their franchisees nationwide.
And where are they, or Little Gym, so it's a franchise, where is it located? Throughout the United States, or how many?
They have about 450 plus locations nationwide, and then some international as well.
And this franchise is going to be owned by Chris O'Shea, is that correct?
Chris O'Shea, correct.
And Chris, K-R-I-S, I believe.
Yes.
O'Shea, O''S-H-E-A. Do you know her background, Chris's?
She was a maternal child nurse for the majority of her career. She is now retired. And in retirement, her and her son decided to get into franchising and started their first Little Gym. They opened the one in Ardmore about 2 years ago.
And can you describe the program?
It's a children's enrichment and motor skill development center. It's non-competitive gymnastics, tumbling, learning center to help children from 4 months to 12 years old develop the skills that they need for life.
Describe how it works. When you say 4 months, what would be the morning and what would be happening in the afternoon?
Yeah, so the morning classes are catered to children under the age of 3. Parents join them during those classes. Typically, there's about 10 to 12 kids in those classes. Only one instructor at that time because all of the parents are in there with them. In the afternoons, that's for the older children, 3 and up, and those classes can be, get to 16 to 18 kids. 18 is the maximum class size.
And so the maximum class size you said is 16, 18?
18 is the max. Yes.
And there's only one class, right? I mean, one classroom.
One class at a time, correct.
And what's the peak number of employees?
3 to 4, depending on the time. 4 would be the peak.
Okay. And how about the hours of operation?
Monday through Friday, it's 9 a.m. to 7:30, and on the weekends, it's 8 a.m. to 6:30.
And open Sunday too?
Sunday, 7 days a week, yes.
Okay. That's all I have.
Okay, so there could be classes offered in the evening time?
Yes.
Is what you're saying? Okay.
Correct.
And then I'm just saying, also for my edification on this as well, I presume, so you're under an LOI right now, or well on your way to a lease then? Because I'm thinking of, we're looking at this considering approval. So if this doesn't go through, would it be back for another retail use and alteration of parking? So just curious, so it seems to be going pretty well?
The lease is basically finalized. We just need signatures on it.
Okay.
Yeah.
Like sixth version, I get
Yeah.
it. So
Yeah.
I know.
Yeah, we don't want to be back here.
Yeah.
Anything else? Okay. Strong.
Thank you. You swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your full name, please.
Kelly, Kelli, Wilson, Wilson. Can I sit down?
Please. I hear you better when you say.
Okay.
Kelly, tell us a little bit about your background.
Good evening. I have 15 years of military and corporate experience managing people, assets, and the logistics and the global supply chain. In 2015, I decided I no longer wanted to work in the corporate world, so I became a personal trainer. I started training people in parks and then in my gym, my home gym, and I just loved it. I think that my love of fitness comes from the camaraderie I had in the military, and I believe that fitness really creates a stronger community, so that's why we're here.
Strong Pilates. Tell us a little bit about Strong Pilates.
Yeah, so Strong Pilates is a Pilates-inspired, low-impact, cardio-infused workout. It's 45 minutes.
And what's your target audience?
Yeah, so our target audience is 25 to 50 years old. Anyone who is sick of having high-impact workouts. We really emphasize the low impact, and we encourage people to come in who are still doing other workouts because it's complementary to other fitness.
And is Strong Pilates located nationwide?
It is, yeah. It's an Australian concept, fitness concept that just came over. It's franchising everywhere. It does not exist here in Pennsylvania yet. This will be the first one.
And you'll be an owner of the franchise?
Yes, owner and operator.
Right. And how many classrooms are there?
One.
One. Again, one classroom. And what's your max size?
18. There will be 18 reformers in the room.
And what's the length of how long is the class?
It's 45 minutes long.
And what's your peak number of employees, do you say? At the peak time?
There could be 3, but
Okay.
most of the time it's going to be 2.
How about your hours and days of operation?
So we're open every day. Our hours of operation are from 5 to 9 Monday through Friday, and 7 7 a.m. to 7 p.m. on the weekends.
And what's your busiest times?
Yeah, so our busiest times will offset, our busiest times will be 5 a.m., 6 a.m., 7 a.m., 8 a.m., 9 a.m., and then maybe we'll have one-offs in the evenings, but we will stay open to accommodate the demand, but most of the people want to be in and out before work, so.
And you foresee any local use of this facility, meaning neighborhood use?
Yeah, like people coming in
Right.
from the neighborhood? Yes, yeah,
I mean, be walking distance.
yes.
Yeah. Okay. That's all I have for Kelly. Anything? Frank? No. Okay.
I do. Frank Tavani, Tavani.
Frank, what's your profession?
I'm a traffic engineer.
Have you testified previously before this board and other boards in the township and other townships regarding traffic engineering?
Yes to all of the above.
Can we have Frank qualify as an expert in traffic? He's been here numerous times. I can go through the whole litany, but let's just. So, Frank, you studied this area and the uses and the parking demand
Yes.
for this site.
Yes.
And what methodology did you use? What did you do?
Did a lot of walking through the community to assess existing parking supply in areas that are most close proximate to the proposed site.
And so, what areas did you look at, and what did you find out?
So I believe my report you said was marked as A8.
Yeah, A8, and actually, that was the one where we mixed up the pages. So now that's the new A8 that I handed to you is the full report with the proper page inserted.
So A8 is 23 pages in total. It's 5 pages of text, 3 pages of figures, and the remainder being supporting material. And at this hour, it'd probably be most helpful to just turn to what's basically page 7.
And that would be on the old A8, unfortunately. I didn't, the summary is what I handed up to the board this evening. The former A8 has the sites that he looked at and the photographs and everything. So when he's referring to page 6 or 7, he's referring to the prior A8. Sorry, I was trying to save trees, I guess.
Yeah, so basically, page 5 was just repeated twice in the original exhibit, and for some reason, it took the place of page 3 as well as page 5. And I guess what you handed up was just the proper page 3.
Correct.
Got it. So that's actually helpful because having that page aside might be more expedient to refer to these figures. So what's on the screen right now is figure 2 for my report, which just shows the overall study area with site outlined near the upper right. But the next page is even more helpful, figure 3, where you can see specifically the 6 sub-areas that I personally polled at different times of day on Friday and Saturday to see what existing parking demand there is. Just going from top to bottom on the right side of figure 3, A is a off-street parking lot maintained by the township that has 62 parking spaces. B is on the north side of Lancaster, essentially across the street from the site, and is 23 spaces. Area C starts at Luella and continues all the way to Wayne Avenue, and it's about 33 spaces. And then at the bottom, you have D, E, and F. D is on the right side of Luella, E is on the left, and F is the school parking lot. And that all adds up to almost 200 parking spaces that are available, 192 to be exact. As you heard from an earlier witness, quite accurately, one of the benefits of this site as proposed is you have disparate parking peaks. We have a proposed restaurant that's going to peak in the evenings, and the little gym and Pilates use will not. They will peak more in the middle of the day or in the early morning perhaps, and also in the afternoon. Nevertheless, if you look to the real page 3, which you can hold separate and look on figure 3 at the same time if it's helpful, I broke my travels down to the different areas that I surveyed. And the numbers shown in these tables on page 3 are observed empty parking spaces. So for example, if you look at the bottom of page 3, at 6 p.m. there were 20 spaces in area A, and then continuing to the right, you'll see there's a total of 104 parking spaces. As we all know, any patron of any of the sites in Wayne is familiar with walking, is familiar with having to go a certain distance and not necessarily parking immediately in front of the site. I tried to choose locations that I thought were reasonable. Quite frankly, there's more parking along Wayne Avenue, for example, that is also not a long walk. I could have polled as well, but I didn't to try and be conservative. But if you look very quickly on the right side of this page, you'll see some triple digits and a lot of entries that start with an 8 or a 9. As you also heard from an earlier witness, we have technically a code deficit of approximately 79 spaces. But again, that's if all the uses are peaking simultaneously, which we know will not happen. We know that there's going to be at least one use that will peak significantly differently than the other two uses, so it's almost sort of a red herring. Nevertheless, if you look at those 79 code-required parking spaces and look at the absolute worst, the lowest number of observed empty parking spaces that I made being 75 in the lower right corner, you can see we're pretty much there. And what all of this analysis excludes, because of the construction currently ongoing, are the 19 spaces on street that will be restored, as we heard from an earlier witness, which will only add to these numbers and make it even that much more likely that there won't be any parking problem at all.
So the parking lots you reviewed or you took counts for were all located near this site?
Very proximate to the site, yes.
Okay, so how about the parking lots? You obviously didn't use the new parking lot that's going to be installed on West Avenue.
No, nor did I look at the large parking lot or large parking area that is most proximate to, say, Christopher's or the train station, which is also nearby.
Right. And what conclusion did you reach after doing the study?
That there is
within a reasonable degree of scientific certainty.
That there is adequate parking to serve this project in the study area.
Thank you. Go ahead.
Yeah, I have a few questions. Just reviewing the study, I'm just trying to get some clarity on areas D, E, and F, just their locations. I've never seen any area in or around Wayne where there's completely available parking for hours on end. So I just am trying to figure out where that is.
So area D is on the east side of Luella. It is the metered parking spaces, starting at Lancaster and going down to Midland, and I'm trying to remember the next street to the south.
Windermere.
Windermere, thank you. Some of those spaces, specifically the ones only between Midland and Windermere, are restricted to school staff only during school hours, school staff being Radnor Middle School. Likewise, the lot at area F.
And D is the lot across the street from the middle school, I guess, gym, that area there, if you're familiar with that.
Yep.
And so I guess just maybe I'm mistaken. I guess what days, this was September the 14th, was there anything going on in the town that day where this might not reflect the normal tendencies of traffic, or is this a standard weekend, and has there been any consideration on that? Just I'm a little surprised to see that there's E, F, D, E, F at kind of the second half of the times, and then area F during the first part of the day, just the total availability. I live 2 minutes from there, so I've never seen that in my life. So just, I'm a little surprised by those.
So Area E are 13 individual parking spaces right up against the field. We already discussed Area D, and Area F is in front of the school. So if you look at page 4 of A8, you'll see this was on a Saturday night starting at 6 p.m. to 9 p.m. And, this part of Wayne currently doesn't have a lot of parking demand because, well, for one reason, the site is currently under construction. There's also another building to the west that's currently being outfitted. I forget the address exactly. But it's the north side of Lancaster Avenue where you have some existing restaurants. Of course, people that go there tend to park in areas A, B, and C. And if you look, you'll see that there is a declination in available parking, especially as the night goes on in Area A. Area B was almost constantly full. And Area C also had some diminution. Again, that's on the south side of Lancaster from Luella out to Wayne. So it's, I think Area F will probably fill up a little bit as a result of this project, and I think it would be a good use of resources, especially since there will be no demand there associated with the school at that time.
Yeah, from a practical standpoint, think about when you go into Wayne on a Saturday night, you always park on the north side of Lancaster. You very seldom park on the south side of Lancaster unless you kind of know it's there and there's no parking available on the north side or difficult parking. Then you'll park down by the post office or that lot on South Wayne Avenue across the street from the middle school. So, I mean, in my experience at least too, I can see that that area is not a heavily used parking in the evening.
Okay, and then I guess second question would be, was there a traffic study done first time around when we figured out that you needed the, I guess, what is it, 43 or 32.7 spots?
Did we do a parking study for that? I know we did a traffic study. We had to.
I think it was a trip generation investigation that was done back in 2022. I didn't bring the entire file with me tonight, but
You guys remember? No parking study?
Yeah.
Okay.
Okay, thank you.
You're welcome.
So I do have a question. So the lot F they're referring to, is that currently available for public use right in front of the school?
Yeah, it is. I mean, it's signed as restricted during school hours, but it's not signed otherwise.
Okay. Yeah, I walk past there all the time.
It's interesting to
and
know
I've
that
never-
that's available,
I've never even
actually.
known
Yeah.
that's available.
Yeah.
So also, one thing I'm just considering here is that, I mean, we have heard just across Radnor regarding parking within the residential neighborhoods. Are there parking restrictions on, let's say, Luella, like, let's say further south on Luella, you have Midland, Aberdeen, St. David's, Windermere. Are there parking restrictions? Are we going to see overflow parking in the residential neighborhoods? Because that's just something that we've heard from residents in general as a consideration.
I did not survey any further south than Windermere as part of this effort. I do know that the spaces on the east side of Luella require payment from Monday through Saturday between 8 a.m. and 6 p.m. So that's the extent of the restrictions, but it's available to anyone, with the exception of during school days between Midland and Windermere only. Then you have to have a special permit to identify that you're working at the middle school to park there.
Okay, so I don't think there are any restrictions.
No, I don't think there are.
On the residential
On
streets.
Windermere and Midland on the east side.
Okay, because
I don't think there are, yeah.
I know a number of residents use a little bit of off-street parking, but I'm just curious if there would be impacts on the surrounding residential neighborhood, especially given that they're also concerned about like the Wawa and everything, so just traffic in general. So just thank you for that.
I mean, as you heard, the restaurant's going to have maybe 90 seats, and that translates to a parking demand of 35, I believe it was, according to code. I think it's unlikely that the traffic will spill into the neighborhood because there's such an abundance of parking that's available more proximate to the site. There would almost be a disincentive to walk that far, especially if it's cold or unpleasant weather-wise.
I have a question. So the testimony that we heard about the tenants that would be coming in, a lot of them are open 7 days a week, pretty much all day, but yet you omitted between 9:30 and 5:30 in your study. Is there a reason?
So I think the restaurant was cited as being open Wednesday through Saturday.
Just answer my question, Mr. Devani. It's late. I heard what the restaurant's hours are. I also heard what the little gym's hours are. And you omitted 8 hours of the time that they're going to be open. So please, just answer my question.
So these hours were originally chosen when there was a consideration for a coffee house at the location. And then as
So
we
they
heard-
bear no relationship to the little gym, for instance? This was for a coffee shop that you did your study,
They do
not the
bear-
little gym?
They do bear some relation. As we heard, there's also going to be an evening component, not only to the restaurant, but also to the Pilates and to the little gym. Some of the parking observations were done at 9 o'clock in the morning. I think that's probably when some of the three and under crowd will start arriving at the little gym. And that was done on both Friday and Saturday. That's the extent of
So,
what I
but
can
yes,
tell you.
to answer your question, there was not a study done between 9:30 and
Yeah, why?
5:30, I guess.
The proposal is that these businesses are going to be open. Certainly Wayne is busy 9:30 to 5:30. Doesn't shut down. People are still there.
So if you go to page 2 of A8, the second paragraph from the bottom, I reference in ITE, and those pages of supporting material that I also mentioned might be helpful here. ITE does give some insight into the parking demands as they vary with time of day for these different uses. And although there isn't anything for juvenile fitness centers or adult Pilates studios, I'm reading now from the beginning of the fourth line from the bottom that begins fitness centers. There is information relative to generic health and fitness centers. As shown, peak parking demand for a fitness use is between 6 p.m. and 8 p.m. on weekdays, and on Saturday, the peak demand is in the morning, beginning at 8 a.m.
That's not even consistent with what we heard from the Pilates proposal. She's there at 5 a.m. I'm not suggesting that Wayne is busy at 5 a.m., but if her peak hours are 5 a.m. to 9 a.m., and yet you're referencing 6 p.m. to 8 p.m. It's okay. I have another question. You did this study in June. Do you recall if school was in session on that Friday?
I believe it was not.
Okay. And would you agree with me it's a fair statement that in the summer in Radnor is not nearly as busy as it would be, for instance, tonight, this coming weekend?
There is a seasonal effect.
That reflected in your report and in your numbers, the seasonal effect?
No, this is only from June.
Okay.
And
Are you
Rich, in
using
fairness-
parking lot F just to bump the numbers of empty spaces so that we're wowed in your chart that there's 104 empties
I
during
didn't
that
hear the
time of
first
day?
part. I'm sorry, I didn't hear the first part of the
They
question.
said, did you include parking lot F, which is in front of the school, in order to bump your numbers to make them look better?
No, I included it because it is a proximate location to the site. And I frankly believe that once patrons of the site realize it's available at certain hours of the day, that they would make use of it.
I don't view people using that site that's right in front of a school.
I don't
personally.
either.
I'm saying for dinner on
I think it was
Friday
a-
night, I think it would probably be very well utilized.
May I speak to?
Is your opinion that there's sufficient parking in
Right,
Wayne? Is
right.
that where you're going with this?
Yes, I mean, as you
Okay.
can see, we have 80, 90, 100 empty parking spaces. I realize it's,
Can I call a timeout and speak to Mr. Tavani for a second? Okay. The reason why this was kind of came up, in fairness to Mr. Tavani, this is when the time he was given to do the study, and you may recall that we had pulled the original application and came back later with a new application. So we really haven't had the time to perform a study for September during school hours, which I would request that we can do that. I would request a continuance so Mr. Tavani can update his traffic report and, address the issues that have been brought up here this evening. I'll give the extension, yeah. Yeah, I'll send a letter out. Next hearing, I guess.
That might be,
No,
is the next hearing October 16th?
yeah, no, or yes?
We have 5 or 6 already, with one continuance from tonight.
Is November okay? Did you already bump some to November, Kevin? I don't know, on that 5 and 6. It's going to be short testimony. It's just going to be an updated report.
We haven't finalized the agenda yet because there was a few deficiencies in a few of the applications, so we're trying to work to see if they're going to be able to submit on time.
No, this will be it.
Can we fit it into October?
It's, if the board wants to have that many appeals on the agenda, sure.
And I think that's fair.
Yeah.
I think that's fair to the applicant. Squeeze it in.
I'll give it granted extension of the, yeah, exactly.
Assuming you get it to the township time.
That's fine. We'll shoot for October, but I'll give the extension to, through the November hearing, yeah. Yeah.
Is that all right?
Just for purposes of clarity for advertising and notice, this will be continued to the October meeting with an extension to November if needed. Thank you.
Okay? All right, thank you.
Okay, we're adjourned. Let me call you. Just about the number.